So, good evening, everyone. My name is Eric Schmidt. I'm commissioner with the Court of Appeals, but tonight I'm being a judge. I'll ask the courtroom manager, is everyone present?
I'm sorry, can you repeat that?
Is everyone present for the trial?
I think that's a better question for the lead attorneys. Thank you. Raiders are all here though.
Okay. Then we'll commence the trial of Kulshan versus Extreme Ski and Sport. Are there any preliminary matters we need to address from the plaintiffs?
Yes, Your Honor. Would you like us to introduce ourselves first?
Yes, please.
Good evening, Your Honor, opposing counsel, and members of the jury. My name is Daniela Castillo, and today I, along with my co-counsels, represent the plaintiff, Nikki Kulshan.
Good evening. My name is Maddie Ondo.
Good evening. My name is Margaret Collins, and now our witnesses will introduce themselves in order of appearance.
Good evening. My name is Sawyer Schultz, but today I will be Nikki Kulshan.
Good evening. My name is Jamie Kim, but today I'll be Jean Von Tramba.
Good evening. My name is Ryan Morel, but today I'll be Valhalla.
Good evening. My name is Marcus Sanchez, but today I'll be Ellery Parser.
Thank you. Counsel for the defense?
Yes, Your Honor. My name is Maythia Goyle. I use she, her pronouns, and today I, along with my co-counsel, will be representing the defendant, Extreme Ski and Sports, Inc. in today's trial. My co-counsel will now go and introduce themselves.
Good evening, Your Honor. My name is Nick Hyland, and I'm co-counsel for the defense.
Good evening, Your Honor. My name is Simran Jawanda, and I'm also co-counsel for the defense.
Our witnesses would now like to introduce themselves in order of appearance.
Good evening, Your Honor. My name is McKenna Baber. I use she, her pronouns, and I'll be portraying the role of Parker Dockbed in today's case.
Good evening. My name is Jaden Tang, but today I'll be Bernie Estepe.
Hi, my name is Arisha Rahman. I use she, her pronouns, and today I'll be portraying Dakota Booker in today's trial.
My name is Anushka Dubey. I use she, her pronouns, and I'll be portraying the role of Grom Atherton in today's trial.
Okay. So that appears to be everyone. Are the bailiffs ready?
Yes, Your Honor.
Okay. Then counsel for the plaintiffs, are there any preliminary matters or motions or preliminary matters we need to address?
Yes, Your Honor. We ask for 2 minutes before the defense's case in chief, in between the defense's case in chief and closing arguments, just so I can set up my video camera.
Okay. That request is granted. Anything else from the plaintiff?
That's all from the plaintiff, Your Honor.
Any matters from the defense?
Yes, Your Honor. We'd like to inquire about your preferences regarding keeping cameras on.
My understanding was that the cameras would be on only for the lawyers and during testimony for the lawyers and the witness. That the lawyers doing the pretrial argument and the opening and closing statements would be on, but the other attorneys would not be. Is that acceptable?
Yes, Your Honor.
Okay. Anything else from the defense?
Yes, we would also like to ask Your Honor that all witnesses be deemed sworn in pursuant to Competition Rule 1.07.
They are so deemed.
We further ask that no witness be excluded from the virtual courtroom, either physically or constructively, pursuant to Competition Rule 4.09.
Granted.
And we request that the clock stop for lengthy impeachments and all objections pursuant to Competition Rule 2.02.
I'll leave the clock running if I think there's a lengthy objection or that someone's trying to eat up time. I'll direct the bailiffs to stop the clock and then restart it. But it won't stop automatically for objections.
Yes, Your Honor. Your Honor, stipulation 2 also states that all exhibits will be admitted into evidence, and would like to clarify that Your Honor also interprets this to mean that counsel can attempt to admit any exhibit, but that each exhibit must still be entered into evidence.
Correct. The exhibits are marked, but they still have to, their admission still needs to be moved.
Yes, Your Honor. And we'd also like to inquire finally about your preferences in regards to screen sharing evidence. Should permission be asked every time evidence is to be screen shared?
Yes, please.
Thank you. No further matters, Your Honor.
Okay,
May I be heard on one of the defense's preliminary matters?
you may.
It is our understanding that time is not stopped for impeachments.
So, correct. It's not stopped for impeachments. I may stop it for if I think there's been a lengthy objection or that there's an attempt to use up the other side's time.
All right. Thank you.
So, okay, if there's nothing further, I see that a pretrial motion has been filed. The movement may begin whenever she's ready.
Your Honor, the plaintiff asks that you bar testimony referring to my client, Nikki Cole, and other mountain bikers as rabid raccoon on rails, squirrels, and other dehumanizing and inflammatory labels from today's trial. These expressions have previously been used in the affidavits of Bernie Estepi and Dakota Booker, and we anticipate that the defense will try to introduce them into today's trial. Today, we are here to decide who should be held liable for the injuries of my client. This type of inflammatory speech sparks prejudice and emotion, distracting from the facts in today's case, and as a result, affects due process. In Peterson versus Moschel, the Washington State Supreme Court made it clear that a case should be argued upon the facts without an appeal to prejudice. In the 53 years since this precedent was set in Peterson, numerous courts throughout the state of Washington have followed suit. These courts established three main questions other courts should consider when looking at speech. Is it biased? Does it pull on the prejudice of the jury? And is it inflammatory? The labels in our case today meet all three. Let's first look at State v. Rivers, in which the appellate court addressed what is and what is not considered biased and prejudiced. In Rivers, a man named Douglas Rivers was convicted of first-degree assault. During the closing argument, the prosecutor engaged in misconduct by referring to Mr. Rivers as a jackal and calling him and others like him hyenas and predators. The misconduct and bias undermined the defendant's due process to the extent that the conviction of first-degree assault was reversed. It was held that these statements introduced so much personal opinion and bias that the court cannot tell if the state would win the case without it. Just as the jackal references in Rivers were improper, so were the rabid raccoon and squirrel labels in our case today. The holding of the most recent Washington State case on this issue, in Ray Richmond, a criminal case, also supports this idea. Although the conviction in Richmond was upheld, it outlines several considerations courts should use when determining whether or not speech, such as animal analogies, are helpful and when they become inflammatory. The holding of Richmond was that context matters, and animal analogies cannot suggest that someone is less than human. In our case today, the label rabid raccoon dehumanizes my client. It compares him and labels him as an animal infected with the disease and conveys the idea that he is less than human. When looking at context, these supposed analogies are said to describe him and other mountain bikers. But the speech in our case today does not directly correlate to the action, like, for instance, fast like a cheetah would. Now, this analogy would describe the apparent speed of the bikers, whereas rabid raccoon on rails has no real descriptive meaning and is instead an unrelated insult. Based on the record, we do not anticipate that these labels will add anything to the jury's understanding of the events. Therefore, they are not intended to give context or to tell a story of what occurred. They dehumanize my client, and they allow Ms. Booker and Mr. Estepi's own prejudice towards mountain bikers to affect the due process of today's trial, which is why we, the plaintiff, asks that you bar the inflammatory labels used by Ms. Booker and Mr. Steffi from today's trial. Thank you.
Thank you, counsel. Counsel for the defense, response?
Yes, Your Honor. The defense asks Your Honor to deny the plaintiff's motion to prohibit animal analogies in testimony and closing arguments. As In re Richmond finds, animal analogies are not inherently improper. Look to examples like lion-hearted, eagle-eyed, or watchdog, each of which are neutral or even complementary. State v. Barajas furthers that animal analogy is a time-honored practice used by both plaintiffs and defendants to help the jury understand the law or the arguments of the parties. For example, in re Richmond, prosecutors compared the defendant to a hornet in order to illustrate his erratic behavior and angry and irrational state at the time of the crime. Not everyone has been exposed to individuals with quick and violent tempers, the court explains, but most people are familiar with the concept of an easily angered hornet. Acknowledging the absence of a fixed rule governing animal analogies, the court found this usage permissible. Similarly, in today's case, the defense's eyewitnesses, Bernie Estepe and Dakota Booker, will analogize mountain bikers to rodents like squirrels and raccoons in order to convey their nuanced observations to a jury who may not be familiar with mountain biker behavior. After all, describing that a biker darted like a squirrel or was acting like a squirrel is far more comprehensible to the average listener than stating that a biker moved at, say, 13 miles per hour. State v. Rivers and In re Richmond went on to define improper remarks as those which are patently racist or dehumanizing. However, the remarks in question today are purely neutral, descriptive, permissible lay witness testimony that are not usually deemed to be disparaging. Take, for example, the phrase rabid raccoons on rails, which simply evokes the uncharacteristically rapid and hyperactive movements of mountain bikers. In fact, the Oxford Dictionary actually defines squirrel as someone moving restlessly or inquisitively. As found in re Richmond, this primary human-centered definition indicates that this analogy is not anthropomorphizing, but rather is anthropomorphizing, not dehumanizing, and is thus permissible. Now, one of the cases that the defense brings up is State v. Rivers, in which terminology such as jackal and hyena was used. The primary difference between this case and that case is that the terms jackal and hyena, they are primarily defined to refer to cheats, swindlers, derogatory human-centered definitions. As we have demonstrated, for example, squirrel, and both raccoon and squirrel do not have primary human-centered definitions. And if they needed to, the witnesses could have chosen a phrase like trash panda, which would actually be intentionally derogatory. Ultimately, as advised in re Richmond, courts should not be quick to take offense to remarks that are not blatantly improper. In fact, State v. Perry has held that counsel is permitted to characterize witness conduct in terms which may be offensive so long as they are in accordance with the evidence in the case. This is because of Evidence Rule 403, which states that the standard for evidence to be considered substantially more unfairly prejudicial than probative is extremely high. This is why, although bias may be a factor, every statement has some bias and it must be unfair prejudice to be excluded. For these reasons, the defense urges Your Honor to allow the time-honored tradition of argument by analogy in today's case and context.
Thank you, counsel. Rebuttal from the plaintiff?
Yes, Your Honor. Now, Your Honor, opposing counsel brought up In re Richmond, and Ms. Goel said that the In re Richmond said that the terms are neutral, but in our case today, that is simply not true. The terms in our case today are not neutral. They are inherently improper. They are biased and they are prejudiced, and they will inflame the passions of the jury. And the other thing is in re Richmond, the court did not exactly say that this speech was neutral. They said that if opposing counsel had objected in trial, they would have actually kept the statements out of court because they were improper and were prejudicial. Now, if you do allow this speech to come into trial, we will object. And we anticipate, as opposing counsel said, that they will respond under 403. Now, 403 states that the prejudicial value must far outweigh the probative value. In our case today, there is no probative value in the labels rabid raccoon and squirrels. They offer no context to the jury and do not help them understand any event in today's case, which is why we, the plaintiff, ask that you bar the inflammatory labels used by Ms. Booker and Mr. Estepi from today's trial. Thank you.
Thank you, counsel. Rebuttal from the defense.
Yes, Your Honor. One of the major differences between this case and many of the others that have been cited throughout is that the defense in this case intends to introduce these analogies through eyewitness testimony as purely descriptive accounts of what their interactions were like. In cases like State v. Rivers and these others, the cases surround a prosecutor characterizing a witness or a defendant in their closing statement, which is a different situation and is more of a rhetorical choice. In this case, our witnesses are simply, for example, with squirrel, referring to the agility and speed that mountain bikers may have moved with, the energy they may have moved with, and this is highly probative of what really happened on the day of the incident and how Mr. Kolshan may have behaved or been pressured to behave. And again, we'd like to remind Your Honor that the standard is for evidence to not only be unfairly prejudicial, but also substantially so. And in this case, the defense would argue that the probative value of this evidence substantially outweighs any danger of unfair prejudice. For these reasons, we strongly urge Your Honor to accept and allow the time-honored tradition of argument by analogy in today's case.
Thank you, counsel. Thank you both counsel for your arguments. I'm going to grant the motion in part and deny the motion in part. I'm going to grant the motion prohibiting the use of the term rabid raccoon. I think it's more prejudicial than, but I'm going to deny the motion as to the term squirrel. I think it's not inherently prejudicial, and it does have probative value. So I'm going to deny the motion as to the term squirrel, but grant it as to the term rabid raccoon. Any questions?
No, Your
If
Honor.
not,
No
if
question
not,
from the plaintiff, Your Honor.
If not, plaintiff may make its opening statement.
Yes, Your Honor. May I begin?
You may.
Extreme Resorts, a well-named company. Ladies and gentlemen, good evening. Today's case is about a mountain resort and the company that operates it, Extreme Skiing Sport. This company, the defendant in today's case, wanted nothing more than to be thrilling and cutting edge, even at the cost of safety. In other words, extreme. My client, the plaintiff Nikki Kolshan, was once an adventurous person. He loved to try new outdoor activities, and he was especially passionate about mountain biking. One day, all of that changed. On May 18th, 2019, Mr. Kolshan decided to visit Extreme Resort at Pato Mountain for an ordinary day of mountain biking. However, this day turned out to be anything but ordinary. Seconds after rounding a blind curve on a trail called the Wonder Trail, Mr. Kolshan was startled by the roar of a nearby artificial snowmaking machine, sometimes referred to as a snow cannon. Before he knew what was happening, he was falling into a huge, deceptively located hole, a hole that had been left untouched and unmarked for 4 months. Nikki hit the ground hard, his bike landing on top of him. He was hurt badly. So, whose fault were his injuries? That is what we are here to decide. Today, we have the burden of proving by a preponderance of the evidence that Extreme Skiing Sport is liable for what happened to Nikki Kolshan. We must prove that they were negligent and that their negligence directly led to my client's injuries. We will meet our burden. Throughout the trial today, we will show you that Extreme Skiing Sport cared about one thing more than anything else: development. They cared more about making Pato Mountain a profitable, thrilling, year-round destination than they did about safety. Ladies and gentlemen, today you will see that in order to live up to the name, Extreme Resort made dangerous decisions. For example, they chose not to repair a massive hole on their most popular trail, the Wonder Trail, a hole which was created artificially by a culvert washout. They chose not to close or make the necessary adjustments to this area of the trail for it to be safe and convenient for all users. They chose not to adequately warn about this dangerous, hard to see hazard in the middle of their trail, not even adding a warning sign for it. It was inevitable that someone was going to get hurt. It just so happens that that person was my client. Now, to prove these things, we will introduce 4 witnesses. First, you will meet Nicky Colshan. He will tell you about his ride on the Wonder Trail that day. As you will learn, he was not sufficiently warned about the dangers of the trail. Not in the waiver hidden within pages of terms and conditions, not in the generic signs at the trailhead, and not as he approached the 20-foot wide hole. Second, you'll meet an eyewitness, an avid skier who, from her vantage point on May 18th, was able to view the Wonder Trail and its layout as Mr. Colshan was approaching the hole. She'll also testify to the startling noise caused by the snow cannon and the lack of warning from its operator before starting it up. Next, you'll hear from a whistleblower, a former Extreme Resort employee who will testify to how the resort chose to prioritize attracting more business, even if that meant risking safety. You'll learn just how easy it would have been for the defendant to have fixed the hole. You'll also learn that instead, the resort's manager preferred to raise the so-called thrill index and leave the hole unaltered for 4 months. Finally, an expert in how humans react to stimuli will explain the necessity of proper signage, warnings, and trail layout in settings such as the Wonder Trail. You'll also learn about the dangers of sudden, startling noises, such as what would be caused by a snow cannon. Pay attention to how all of these factors played into what happened on May 18th. You'll see, ladies and gentlemen, that this resort was right to call itself extreme. We will show today that this company's negligent decision-making directly led to my client's injuries. Today, ladies and gentlemen of the jury, it is your solemn responsibility to listen to the evidence and ensure that justice is done. At the end of today's trial, my co-counsel, Ms. Castillo, will ask you to find the defendant, Extreme Ski and Sport, liable. Thank you.
Thank you, counsel. Opening statement from the defense.
Yes, Your Honor. This is a case where someone is searching for a scapegoat. Someone is diverting blame due to their own fall from fame. Today, you will see that that someone is the plaintiff, Nicky Colshan. Today, Colshan's team will attempt to spin a story of how my client, Extreme Ski and Sport, recklessly and dangerously manufactured an obstacle on one of their mountain biking trails. Colshan's team is accusing my client, Extreme Pato Pass Resort, the branch of Extreme Ski and Sport in question, of negligently operating that trail, called the Wonder Trail. However, today the defense will prove beyond a preponderance of evidence that Extreme Ski Resort did not negligently operate the trail and that it was the recklessness of the plaintiff, Nicky Colshan, that is to blame. The management of Extreme Ski and Sport has always done its best to provide for its customers. The chief of operations of the resort, Parker Dockabed, grew up around the mountain, falling in love with it, wanting to preserve its qualities for future generations. For 10 years, she, along with her head of physical plant operations, Bernie Estepe, would work together to maintain Extreme for everyone who came. For that decade, business was great, with Extreme rarely receiving any complaints and criticisms and being packed during the winter months with skiers and snowboarders and getting a fair amount of use during the summer months due to its extensive hiking, horseback riding, and mountain biking trails. For that decade, everyone who came to Extreme would have a great time. And then one day, Nicky Colshan showed up at the front gates of Extreme, and that is where our story begins. On May 18th, 2019, Extreme was serving skiers and snowboarders a refuge for the last winter sport enthusiasts of the season who were seeking to cash in on the remaining snow. Most of the staff were focused on maintaining the trails in a safe condition or serving customers in the main lodge, meaning that when a car pulled into one of the parking lots in mid-afternoon, it went fairly unnoticed. Out of that car would step Nikki Colshan, who would go on to ride the Wonder Trail. Colshan would record their entire ride for their YouTube subscribers as they zoomed past hikers and a horseback rider. Colshan would go around a corner and launch off a gap feature, crashing on the ground, sustaining significant injuries that required surgery. Colshan is now suing Extreme for their physical injuries, for their self-diagnosed PTSD, and for the financial hit caused by their fall from fame. Throughout the testimony of the witnesses, you too will see how Colshan is simply searching for a scapegoat. You will hear from Parker Dockabed, the chief of operations at Extreme, who will tell you of her role at the company, of the operations of the Wonder Trail, and the safety standards that everyone is held to on the Wonder Trail. You will hear from Bernie Estepe, the head of physical plant and operations at Extreme, who will tell you of the responsibilities of his position, of the manufacturing of artificial snow at Extreme, and the validity of Colshan's claim that ice and snow shards hit them in the face. You will hear from Dakota Booker, a mother of two and small business owner, who will tell you of her interaction with the plaintiff on May 18th. And you will hear from Graham Atherton, a professor in psychology, which is the study of the ethics of mountain biking, who will tell you of the safety standards that Extreme Ski and Sports and Nikki Colshan were held to, and whether Extreme Ski and Sport met those standards, and whether Nikki Colshan met those standards. Extreme Ski and Sport was operating just fine, with only happy customers leaving Pato Mountain. It was up until Nikki Colshan recklessly rode the Wonder Trail that anyone had a problem. And now Colshan is diverting blame due to their fall from fame. At the end of this trial, the defense trusts that you will come to a verdict of not liable. Thank you.
Thank you, counsel. Plaintiff may call their first witness.
The plaintiff calls Nikki Colshan to the stand. Please introduce yourself to the court.
Hey, my name's Nikki Colshan.
What do you do for a living, Mr. Colshan?
Well, I'm a hiker, mountain biker, rock climber, parasailer, just kind of general outdoor enthusiast, but I'm especially into mountain biking.
How long have you been mountain biking for?
I've been mountain biking 6 or 7 years, but I haven't been able to mountain bike since May 18th of 2019.
Why is that, Mr. Colshan?
That's when I injured myself while mountain biking on a trail called the Wonder Trail.
Well, let's talk a little bit more about May 18th of 2019. Could you tell us more about what you were doing that day?
Yeah, like I said, I was mountain biking. I'd gone up to a resort called Extreme Ski and Sports at Pato. So I just drove up there and parked that day.
And you mentioned that you went on the Wonder Trail. Had you been on the Wonder Trail before?
Yeah. Me and my dudes had been up there a few times before. It was nothing too tough that I wouldn't be able to handle. So I thought it'd be a good one to do that day.
And did you see anyone on the Wonder Trail that day?
Yeah, I saw some hikers and I saw some horseback riders. Nothing I wouldn't have been expecting. I've been on parts of that trail before. So,
Mr. Colshan, if I were to show you a diagram of the Wonder Trail and the surrounding area, would you recognize it?
Yeah, I think I would.
And if I were to show you a picture of the Wonder Trail itself, would you recognize it?
Yeah.
Your Honor, permission to screen share what has been previously marked as Exhibit 1 and Exhibit 2.
Granted.
Starting with Exhibit 1, Mr. Colshan, what is that?
That looks like a map of part of the Wonder Trail I was on May 18th and the surrounding area.
Is this a fair and accurate depiction of the Wonder Trail and the surrounding area?
Yeah, looks like it.
And what is Exhibit 2?
That looks like a photograph of the Wonder Trail.
Is it a fair and accurate depiction of what the Wonder Trail looks like?
Yeah, I'd post that on my Insta.
Your Honor, the plaintiff offers Exhibit 1 and Exhibit 2 into evidence.
Any objection?
No, Your Honor.
Exhibits 1 and 2 are admitted.
So, Mr. Colshan, starting on the left, could you explain for the jury what's on Exhibit 1?
Yeah, this red line here is the Wonder Trail. That's what I was on. Over to the right here is the Dogs Lake ski run. So that's over to the side of the Wonder Trail, elevated up above a little bit. On May 18th, I started up here at the top of the Wonder Trail and worked my way downhill.
And you mentioned that you got hurt on the Wonder Trail. Is that shown on the diagram?
It is, yeah. It's this big, massive hole right here in the middle of the trail. You can see it here.
Now, looking at Exhibit 2, Mr. Colshan, is this view in the picture, is it looking down the trail or up the trail?
That's looking down the trail, so the direction I was going on May 18th.
So what was on your left side as you went down the trail?
Yeah, you can see it here. It's this big rock face. So up above me would have been the Dogs Lake ski run overlooking the Wonder Trail.
And what was to your right side?
You can kind of see it in this picture. It's like this big, massive drop off. So it was a real tight trail there between the rock face and the drop off.
And you also mentioned earlier that you saw some horses. Could you point out where that was on the Wonder Trail?
Yeah, it was at this curve right here, this last one before the hole, a lot like the picture over here in Exhibit 2.
So what did you do when you saw the horses, Mr. Colshan?
Like I said, I've dealt with horses before. I've gone horseback riding myself. I just carefully made my way by.
So what happened after you passed the horses?
After I passed the horses is when I rounded the corner and went into a short, straight incline. And that's kind of when everything happened.
All right, well, let's talk about that. What happened once you went around the curve and were in this straight incline?
The first thing I remember, suddenly this crazy loud noise started up. Picture something louder. It was like a truck starting up in my head, and that really startled me.
Did anything happen after this loud noise?
For sure. There was these ice pellets that came down on my face, totally blinding me.
And what do you remember that happened next?
I remember my wheels weren't touching the ground anymore. I was falling for what felt like a long time, landed, I guess, in the bottom of the hole, and my bike came down on top of me. It was messed up pretty bad.
So, Mr. Colshan, I'd like to clarify something. On May 18th, did you see any signs at the trailhead?
I did, yeah. They were just your typical trailhead signs.
Did these signs say anything about the massive hole in the Wonder Trail?
Definitely not.
As you went along down the trail, did you see any signs mentioning the hole in the Wonder Trail?
I didn't see any signs at all as I went down the trail.
So, Mr. Colshan, when did you become aware that there was a massive hole in the middle of the trail?
I guess when I woke up in it.
Thank you. No further questions.
Cross-examination?
Yes, Your Honor. Good evening, Mr. Colshan.
Evening.
Let's talk a little about your social media presence. You've actually made millions from social media, right?
At one point, I was bringing in a lot of money. Yeah, millions.
You've testified that you share your mountain biking rides with fans, right?
I don't think I testified that, no.
But you do share your mountain biking rides with fans on Shillue, right?
I do occasionally upload my results from Shillue.
You share all of your results with your followers, right?
I share everything with my followers, but I only upload once in a while.
I want to talk about one particular ride that you shared with fans. In mid-2018, you went mountain biking near Mount St. Helens, correct?
That's right, yeah, me and my dudes.
You're not sure whether the trails you used were actually legal though, right?
Objection. Improper character evidence under 404B.
Response?
Yes, Your Honor. Under 404B, character evidence is inadmissible if it goes towards conformity, but in this case, the character evidence is going towards Mr. Kolshian's motive. This line of questioning is going to demonstrate the level of risk that Mr. Kolshian may have felt obliged to take, as even the risk of using a trail that may have been closed or illegal caused fans to complain about Mr. Kolshian's wimpiness or lack of risk-taking, and this will be shown to have directly influenced Mr. Kolshian's motives and mindset on May 18th, 2019.
May I be heard, Your Honor?
You may.
Your Honor, opposing counsel is using this testimony about Mr. Kolshian going on an illegal trail to show that his character conforms to being risky and is therefore inadmissible under 404B.
Okay, I'm going to sustain the objection. I think it's propensity and evidence. You may
Yes, Your Honor.
continue.
After this ride, fans complained that you had downgraded to wimp experiences, failing to take risks like in previous activities.
Yeah, people post comments that say stuff like that.
This bothered you at the time, right?
Yeah, but whatever you do, you're always going to get some negative feedback.
Well, this still bothered you a year later when you took your May 18th, 2019 bike ride, right?
I mean, yeah, negative comments can bother me. Like, it's hard to hear some of that stuff about yourself. But I always say to those fans, they can go and watch the dudes who are doing more extreme stuff on their social media, whatever.
Well, Mr. Kolshian, is that a yes to my question that these comments still bothered you about a year later?
Yeah, I mean, not the same specific comments exactly, but negative comments.
And so you only intended to upload the video of your ride for followers if it was exciting?
That's how I always ride.
All right, let's talk a little about your May 18th ride on Extreme's Wonder Trail. Before this ride, you purchased a parking pass from Extreme's website, right?
That's right.
You were presented with the terms and conditions of use, right?
That's right.
You read through about 8 to 10 paragraphs?
Yeah, I printed them out and I read up to, I don't know, where it was talking about motorized vehicles on the trail or something.
But in order to purchase your pass, you checked a box indicating that you had read and agreed to all of Extreme's terms and conditions, right?
Yeah.
Let's talk a little about your preparation for the ride. You mentioned that you had biked on portions of the Wonder Trail before May 18th, right?
Yeah, me and my dudes had been up there the year before.
You found these rides challenging, right?
Yeah, but nothing an experienced biker like myself couldn't handle, nothing too chunky,
So that's a yes to my question. You found these rides challenging.
Yeah, but fun.
But for your ride on May 18th, 2019, you purposely sought out a segment that was a little more dangerous or chundery, right?
Yeah, something with a little more chunder, but just, more chunder than a typical machine built trail. Nothing, no taco fest like they got at North Plateau.
So is that a yes to my question?
I guess you got to be more specific. More chunder than what?
Well, in your own words, you wanted to find a segment with a little more chunder that was a little more dangerous than the rides you had taken previously, correct?
No, that's not correct.
You wanted to find a segment with a little more chunder than the machine-built trails that you had ridden on previously, correct?
I wanted to find something with more chunder than a machine-built trail. That's right.
So that's a yes. Friends had warned you that the area had some serious sections filled with large stones near a drop-off feature?
Yeah, baby heads near a drop-off, yeah.
When you got to the Wonder Trail on May 18th, 2019, you told us that you saw warning signs at the trailhead, right?
Yeah, typical trailhead signs.
You were running late with the sun already starting to set, right?
Yeah, I got up there a little later than I wanted to in the day.
And yes or no, Mr. Kolshian, you decided to go downhill to work up more speed.
Yeah, when you're mountain biking, you gotta go downhill to work up speed in case there are any difficult and terrain at the bottom of the hill, so you can get over that.
No further questions, Your Honor.
Any redirect?
Yes, Your Honor. So, Mr. Kolshin, I'd like to begin with on cross-examination, you were asked about some negative comments.
Yeah.
Did any negative comments that you had been receiving affect the way you wrote on May 18th?
All right.
Objection, Your Honor, leading.
Overruled.
Yeah, all right, how I ride. No comment's going to change that.
No, you were also asked about some terms and conditions, Mr. Kolshin. Did these terms and conditions say anything about the hole you saw on the Wonder Trail that day?
No.
Thank you. No further questions.
Any recross?
No, Your Honor.
Witness is excused. Plaintiff may call their next witness.
Yes, the plaintiff now calls Jean Von Tromba to the stand. Please introduce yourself to the court.
Good afternoon. My name is Jean Von Tromba. I'm a paralegal at Alki City Law Firm, a avid skier, and a proud mother of two.
Ms. Von Tromba, how are you involved in today's case?
I'm an eyewitness. I watched Nikki Kolshan unfortunately be injured, so I'm here to recount what I saw.
Ms. Von Tromba, before May 18th, did you know or know of the plaintiff?
No, I did not.
But were you familiar with Extreme Resort?
Yes, I was. I've been going there since middle school.
All right, I'd like to talk about May 18th. What were you doing that day?
Well, that day I wanted to bring my kids with me to see the wonders of the mountain. I thought we could have a great family bonding experience. It would just be wonderful. You know, they did bond quite a lot. They bonded a lot with their cellular devices and my ex-husband, Craig. They decided that they were tired and wanted to stop at the lodge.
Well, did you stop when your kids got tired?
No, I didn't. I decided I wanted to go on one last run on the Dog's Leg ski run. It was great. I had the run almost to myself. There were no kids hurtling down the mountain. There were no teenagers falling over in the middle of a narrow passage. It was going wonderfully.
Would you recognize a diagram of the Dog's Leg ski run?
Yes, I would.
Your Honor, I now ask permission to screen share previously admitted Exhibit 1.
Permission granted.
All right, so what are we looking at here?
Right, so here is the Dog's Leg ski run where I was, and here is the Wonder Trail that is next to it.
And could you point out some of the important symbols on this diagram?
Yes, so this blue dot right here is the snow machine, and the shape above it is the snow machine control shed.
So when you were going down the Dog's Leg ski run, did you end up going all the way down?
No, I didn't. As I was going down, I saw someone head towards the snow machine control shed, and realizing what would soon follow, I just decided to stop and wait out. I stopped right at this X here.
While you were waiting, what did you do?
Well, I decided to just kill time and look at the trail next to me.
What did you notice about the trail?
Well, the trail was rather rough and irregular. An area had been washed out, creating a hole, and there was a pipe sticking out at a weird angle.
You mentioned that the Dog's Leg ski run and the Wonder Trail are next to each other. Is there anything between them?
Yes, there is. They're not directly next to each other. The Dog's Leg ski run is actually at the top of a cliff. I'm not a great judge of distance, but I'd say it's maybe 40 feet tall. Additionally, at the edge of the ski run, there is a fence. It's to stop skiers from just falling right off the cliff.
So to be clear, Ms. Von Tromba, from up on this 40-foot cliff, could you see the washout area?
Yes, I could see it quite well.
And from your vantage point, did you see anybody on the Wonder Trail?
I did. I saw some horseback riders coming up and a mountain biker coming down.
You can take down that exhibit now. And do you now know who this mountain biker was?
Yes, I am now aware that it is the plaintiff, Nikki Kolshan.
And you mentioned some horseback riders. What were they doing?
Well, they were slowly picking their way up the rocks.
Compared to these horses, How fast did it seem like Mr. Colshan was moving?
Well, Mr. Kolshan was moving a little faster than the horses, but no one was really moving that quickly overall.
Well, what happened after Mr. Colshan was going down the trail?
Well, after Mr. Kolshan went down the trail, he passed by the horses and he went around a curve. This curve was in shadows, so I couldn't see him for a couple seconds. When he emerged, he headed straight towards the washout area, then tried to pull back or sideways or something like that. And then the snow cannon went off.
Miss Von Tromba, before the snow cannon went off, did you see its operator look over the cliff?
No, I did not.
And did you hear the operator give any sort of warning?
No, I didn't.
Well, what happened when the snow cannon did turn on?
Well, I jumped. It was totally shocking. I was quite a while away, but it still surprised me. I looked over it for a moment on instinct. When I looked back, my vision was obscured by a sort of vapor. When the vapor had cleared, I saw Nikki Kolshan fall into the hole.
And then what happened?
Well, Nikki Kolshan hit the bottom of the hole. He and his bike flipped over, and when he crumpled to the ground, he was prone with his bike just bent on top of him.
Thank you. No further questions.
Cross-examination?
Yes, Your Honor. On May 18th, 2019, you stopped at the side of the Dog's Leg curve to avoid the snow cannon startup, correct?
Yes, I did.
And you estimated that the cannon had a 50-foot arc, right?
On a prior experience with the snow cannon, I strayed 50 feet away from it.
Okay. But you don't consider yourself a good judge of distance, right?
Unfortunately, I cannot perfectly measure, so no.
And from the slope, you were looking straight down on the washout feature.
Yes, I was looking down at the washout.
So you couldn't tell how deep the hole was, correct?
No, I couldn't.
And next, moving on to the incident itself. You were able to watch Kolshan's encounter with Dakota Booker unfold, correct?
Yes, I watched Nikki Kolshan interact with a horseback rider.
And so you saw Kolshan coming down the trail, correct?
I did.
Kolshan seemed to be practicing tricks on the trail, weren't they?
Objection, speculation.
Overruled.
No, I really wouldn't be able to say for sure whether or not he was practicing tricks.
But Kolshan did speed past the horses, didn't they?
Yes, Kolshan passed by the horses.
And they did speed a bit, or go a little bit, they did speed up a bit, correct?
They accelerated a bit from their already quite slow speed.
And the horse in the back buckled up after seeing Kolshan, correct?
This was before Kolshan went past the horses, but yes, the horse did buck up.
And Kolshan threw up their arm at the horse, didn't they?
Yes, or perhaps at its rider. I can't be sure.
And Kolshan threw up their arm while speeding up, didn't they?
He threw up his arm before he accelerated.
And Miss Tromba, this all happened before the snow cannon went off, didn't it?
Yes, this happened before the snow cannon.
Thank you, Your Honor. No further questions.
Any redirect?
And Your Honor.
Okay, and the witness is excused. Plaintiff may call their next witness.
The plaintiff calls Valhalla to the stand. And before I begin, may I ask the bailiff how much time the plaintiff has for direct examination? Thank you. Would you please introduce yourself to the court?
Hello, my name is Valhalla.
Good evening, Mr. Hollana. What do you do for a living?
Well, currently I'm between jobs, looking for work, whatever you want to call it. But I used to work for Extreme Ski and Sport up at Mount Plateau.
How long did you work for Extreme?
7 years total. I was an intern for the first year, and then they brought me on full time to work as the vice president of risk management and product development.
What did you do as vice president for risk management for Extreme?
Well, risk management at a ski resort is a little different than most risk management jobs. Most of my work revolved around educating our customers so they didn't get themselves into trouble. This mostly revolved around putting up signs, making sure waivers were where they needed to be, just making sure the flow of information was going smoothly.
All right, now I want to talk about May 18th. Were you working on May 18th?
I was not, no, it was my day off, so I was not at the resort.
Are you aware what happened on May 18th?
I am aware of Mr. Colshan's crash on the Wonder Trail, yes.
Had you ever been to the Wonder Trail before May 18th?
Yeah, I'd been out there a couple times for work.
Were you aware of the hole on the Wonder Trail before May 18th?
Oh, yeah, that hole had been there for quite a while, so I was well aware of it.
When did you first learn about this hole?
Well, back in January of 2019 is when we first found out about it.
All right, now I want to talk a little bit about the area around the hole and the Wonder Trail. What does the geography around the Wonder Trail look like?
Well, I mean, using the hole as a sort of convenient center point, if you were to go north, you would be heading uphill to the upper trailhead. If you were to go south, you would be heading mostly downhill to the lower trailhead. If you were to go west from the hole, you would go down a ravine into what we call the Roaring Gulch, which is the natural drainage system for that side of the mountain. And if you were to go the other way, east from the hole, you would be basically scaling a cliff to get to one of our popular ski runs called the Dog's Leg, which has a snow cannon as one of its main features.
Now, how does water get up to these snow machines?
Well, I mean, they have pipes, of course, that funnel water from below the mountain or from the mountain streams, basically.
Have you had issues with these pipes before?
Yes, we did. A couple weeks before the hole was created, back in January of 2019 again, we had a line break, so basically a pipe burst, and that runoff from that pipe burst drained down onto the Wonder Trail through the culvert and then into the Roaring Gulch.
All right, now I want to transition back to the hole we were talking about earlier. Now, did you ever go to inspect the damage to the Wonder Trail?
I did, yes. I went out there pretty much as soon as we found out about it, just to, as risk management person, see what we were working with, how it looked, what we needed to do, that sort of thing.
And when you went to go look at the hole, what did you observe about the Wonder Trail?
Well, I personally thought it was in pretty miserable condition. I mean, imagine a hiking trail, just your average hiking trail, and then imagine a full 20-foot stretch of it just missing. It was, as I said, miserable to say the least.
Was anyone with you when you went to inspect the damage to the trail?
Yes, I was with my boss, Parker Dacabed, and a sort of representative from the corporate offices, Chase Bale.
Who is Chase Bale?
Well, as I said, she works from the corporate offices, specifically in trail construction and trail management. That I believe that's the title, but she was there to just sort of advise us on what to do.
Well, what were you advised to do about the hole?
Ms. Bale, as we learned, was a pretty avid mountain biker, and as a mountain biker, she
Objection, Your Honor, hearsay.
May I be heard, Your Honor?
You may.
Your Honor, this is admissible under 801D2D. As Mr. Hall just clarified, Ms. Bale was a representative from Extreme sent to talk to them about the hole, and therefore she is a speaking from Extreme, and this is admissible.
Your Honor, may I respond?
You may.
Your Honor, the party opponent in this case for the plaintiff would be Parker Dacabed. While Chase Bale was sent in as a representative, Parker Dacabed would have been the designated higher up than Chase Bale and would have been the designated party opponent in this case.
Okay, I'm going to overrule the objection. Witness may answer.
Right. Would you like me to ask the question again?
Yes, that would be great.
What were you advised to do about the hole from Ms. Bale?
Oh, yes. Well, as we learned, as I said, Ms. Bale was a pretty avid mountain biker, and as a mountain biker, thought the hole would be a great feature for the Wonder Trail and advised us to keep it as it was.
What did Parker say about the hole?
Well, Parker's actually where it gets a little more complicated, because originally Parker and I were on the same page and thought, this hole is pretty big, it could be dangerous, we should fix it as soon as possible. But after talking with Ms. Bale, Parker was pretty set on keeping the hole as a mountain biking attraction.
Did Ms. Bale talk about any trail safety issues regarding the hole?
As far as I could tell, she did not know.
Did you ever follow up with corporate office about what to do about the hole?
We did, as I said, Ms. Bill was in this capacity, basically the representative for the corporate offices. But we did, have a meeting to say, hey, here's what we're doing. We're just going to keep the hall as it is. And they said that was fine, of course. And they did offer to clean up the lower part of the trailhead.
Was the lower part of the trailhead ever cleaned up?
Not before Mr. Colshan's crash on the Wonder Trail, no.
Objection, Your Honor. Remedial actions.
May be heard, Your Honor.
You may.
Now, opposing party just referenced 407, which is subsequent remedial measures, but this is not a subsequent remedial measure, as a subsequent remedial measure has to be taken after Mr. Colshan's accident, which, if taken before, would have helped to prevent against it. Now, not cleaning up the trailheads before Mr. Colshan's accident is not a subsequent remedial measure.
Your Honor, may I respond?
You may.
Your Honor, under Rule 407, an action taken after a certain event, such as a crime or after Colshan's crash, in this case, is not admissible to show any ill intention or recognition of fault. The way that the witness stated his answer, it very much implied that Extreme saw this as a wrongdoing on their own half and therefore fixed the hole, as he stated. And after the crash, they fixed the washout.
Okay. Objection overruled. Witness's answer will stand. You may ask your next question.
All right, now I would like to talk a little bit about the signs you mentioned earlier. Now, before the washout, were there any signs warning about the Wonder Trail?
There were a couple signs at the two trailheads for the Wonder Trail, yes, but they were just sort of the general average trailhead signs, dangerous natural terrain ahead, share the trail, that sort of thing.
Was the whole part of the dangerous natural terrain when these signs were placed?
Oh, no. Those signs had been there for long before the hole was ever formed.
And were there any signs along the Wonder Trail?
No, as far as I know, the only signs on the Wonder Trail are at the two trailheads.
Now, after the hole was created, did Extreme put up any new signs to warn about it?
They did not. No, I actually spearheaded a sort of campaign to, put up some signs. I went to Parker and said, hey, we have this new pretty big development on the trail. We should, warn about it. It can be kind of hard to see. So I said that and offered to, spearhead that campaign, but my idea was shot down pretty quickly, so nothing came of it.
Well, after inspecting the hole and the area around it, do you think warning signs would have helped to warn about it?
I do, yes. And as I said, the hole can be quite hard to see, especially when you're coming from the upper trailhead, heading down towards the lower trailhead. So you're heading around a corner, up a hill, sometimes in and out of light. It can be a little complicated. So I thought just having a sign there would be a safe bet.
If no additional signs were put up, how did Extreme warn about the danger of the hole?
Oh, well, they didn't.
Thank you, Your Honor. No further questions.
Cross-examination?
Yes, Your Honor. Good evening, Mr. Hollow.
Good evening.
Mr. Hollow, you constructed a number of warnings and waivers for Extreme. Is that correct?
Yes, in my years there, I did, yes.
You advocated for these warnings to be more significantly displayed. Is that right?
Yes, I think the way our terms and conditions work as they are right now are a little hard to notice, hard to see, and I thought that having them more prominently displayed would help.
And yet, these warnings didn't specifically mention the washout, did they?
No, some of the warnings I suggested were before the washout, but even the ones after didn't specifically mention it.
The warnings didn't specifically mention the snow cannon, did they?
No, I believe there are already some warnings about the snow cannon in the waiver.
Thank you. Mr. Hollett, you've worked at previous jobs before working at Extreme, is that correct?
I have, yes.
At your first job, you worked at a soccer venue, is that right?
This is inadmissible under 404 or 403B, past actions used to prove future conduct.
Your Honor, may I respond?
You may.
Your Honor, under 404B, character evidence is admissible for purposes of identity. In this line of questioning, I'll be going to show that it is within Mr. Hollow's identity to worry about safety a bit more than most people. And due to this, this line of questioning and the character evidence that is shown from it is admissible character evidence.
May be heard, Your Honor.
You may.
The way the line of questioning is going, it implies that opposing counsel is going to bring up Mr. Holla's past jobs to prove future conformity in his old job at Extreme, which is inadmissible under this rule.
Your Honor, may I respond?
No, I'm going to rule. I'm going to overrule the objection at this time.
Mr. Holla, you worked at an indoor soccer venue, correct?
I did, yes.
And you had a manager at that job?
I did. I was working under someone.
And you had disagreements with that manager, correct?
I did have a
Objection, Your
couple.
Honor. This is inadmissible as he is trying to use past actions to prove future conduct.
Response?
Your Honor, again, under 404B, this shows a conformity to Mr. Holla's identity, which is as a compassionate person who cares a bit more about safety. And because of that conformity to that identity, this is admissible character evidence.
May be heard, Your Honor.
You may.
This is not talking about Mr. Holla's identity. In fact, opposing counsel is using this to show Mr. Holla's past disagreements with his previous employers and use it to prove future conduct in the future at Extreme.
Okay, at this point, I'm going to sustain the objection to this question.
Mr. Holla, you had disagreements with this manager on the issue of safety, is that correct?
Objection, Your Honor. This question goes to exactly what the previous sustained objection was referring to.
May I respond, Your Honor?
Briefly.
Your Honor, this time it has been added on that this is character evidence towards safety, which then goes to the identity of the character.
Yeah, objection sustained. Ask your next question, please.
Mr. Holla, you had disputes and disagreements with Parker Dockabed, correct?
I did, yes.
Even though Parker seemed to listen to your ideas?
At first she did, yes. But as I had more time with the company, we had a couple run-ins with some things that we didn't quite agree on.
She seemed to value your experience, didn't she?
Again, at first she did, yes.
And yet you reported her directly to corporate, is that right?
I went to corporate because I felt I wasn't being heard. And again, this was later in my employment. Originally, if I could clarify, we did get along quite well, but pretty much starting with this dispute at the hole in the Wonder Trail, we had a couple run-ins with each other where we weren't quite agreeing on our vision for the company. And because of this, I went to corporate to ask that my voice be a little more heard.
You did not report her directly to corporate? You did not report her to corporate?
I wouldn't use the word report, but I did go to corporate to have them intervene and, make it so I was a little more heard as their vice president of risk management and product development.
You were then fired by Extreme, yes or no?
Yes, I was fired for going to corporate and asking for help for what they called insubordination.
You believe the company to be immoral, don't you?
For that very reason, yes.
So safe to say you very much dislike Parker Dockabed, don't you?
I have nothing personally against Parker Dockabed, but I do have something against the company of Extreme Ski and Sport.
You hold no grudges against Parker Dockabed, even though you reported her directly to corporate?
Well, I have a grudge with her position, not with her person.
Thank you, Mr. Holla. That's all.
Redirect?
No, Your Honor.
Okay. Witness is excused. Plaintiff may call their next witness.
Your Honor, the plaintiff calls Ellery Parser to the stand. And before I begin, may I ask the plaintiff how much time the process? Thank you. Would you please introduce yourself to the court?
Hi, I'm Ellery Parser.
What do you do for a living, Mr. Parser?
I'm an ergonomist and a human factors consultant.
What do you do as an ergonomics and human factors consultant?
I analyze work environments to see how workers at their jobs interact with the stimuli they face.
What are your qualifications as an ergonomics and human factors consultant?
I have a master's in ergonomics from the University of Central Utah, along with a bachelor's in psychology from Indiana Western.
What aspects of today's case have you looked at?
I've looked through all the witness statements and examined all the exhibits, including the signs in Exhibit 6. And I also personally visited the trail, especially the portion where Mr. Colchon suffered his crash. I also took the chance to hear the snow cannon on site.
And are these materials, such as the affidavits and signs that you used, reasonably relied upon by other experts in your field when forming opinions?
They are.
All right, well, I want to talk about those signs that you mentioned. Are you familiar with the signs on the Wonder Trail?
I am, yes.
Would you recognize those signs if I showed them to you today?
I believe I would.
Your Honor, permission to screen share and show Exhibit 6.
Granted.
Now, Mr. Parser, what is in front of you?
In front of me are a photo of 3 of the signs that were located on the Wonder Trail when Mr. Colchon had his crash.
And is this a fair and accurate representation of those signs?
It appears so.
Your Honor, the plaintiff offers Exhibit 6 into evidence.
Any objection?
No, Your Honor.
Exhibit 6 is admitted.
Now, Mr. Parser, what criteria do you look for when you examine signs?
When looking at signs, we mainly look at 2 things. We look at design and content.
What about design? What do you look for?
For design, we look at a sign's shape, a sign's color, and how a sign separates itself from its environment.
What about content?
For content, we look at a sign's wording. Is the wording clear enough? Is it concise enough? And does it adequately address the dangers that lay ahead?
Well, let's look at this first sign here. Does this first sign meet the criteria for an effective warning sign?
No, it doesn't. Let's start with the design. Here we have a muted yellow hue along with a rectangular shape, which could easily be disguised by trees and shrubbery. Then there's the wording which says, "Caution, please enjoy trail at your own risk." Now, this is far too broad of a statement as it doesn't address a particular danger.
Well, what about this second warning sign? Does this meet the criteria for an effective warning sign?
No, in fact, this doesn't even meet the criteria for being a warning sign at all, never mind an effective one.
All right, well, what about this third sign? In your professional opinion, is this an effective warning sign?
Again, no. Here we have a brown tone with a rectangular shape, which could blend into a woody environment. The sign also says, "Caution, difficult or dangerous terrain ahead," which again is far too general of a statement, as it doesn't specify one danger, nor does it provide any direct instructions.
Now, Mr. Parser, do any of these signs mention a loud noise?
No.
You may take down the exhibit. Now, you mentioned earlier that you were able to read all of the witness affidavits. Do you remember reading about a loud noise that went off on the 18th?
I do, yes.
Well, let's talk about that loud noise. How do loud noises affect a person?
Loud noises can elicit a startle reflex in the vertebrae, which affect what we call the 2 C's, concentration and coordination.
Mr. Parser, you also mentioned that you had been to Extreme and examined the snow machines yourself. Were you able to hear the noise they produced?
I was, and may I say, it was quite loud.
In your professional opinion, how could the loud noise you heard have affected someone's focus when riding on the Wonder Trail right before the hole?
The loud noise could have caused a person to divert their attention away from the task at hand and proceed in an unsafe manner.
How do companies minimize the startle effect from loud noises produced by snow machines?
Companies do one of 2 things. They're either more careful with the production of this loud noise, making sure that no one's nearby when it occurs, or they find some way to muffle this noise so that no nearby users are affected by it.
Did Extreme do this?
No.
Thank you, Your Honor. No further questions.
Cross-examination?
Yes, Your Honor. Mr. Parser, this is your first time testifying about whether an outdoor resort owner breached their standard of care, right?
Yes, this is my first time talking about an outdoor resort.
And this is only the second time you've ever been asked to review conditions in an outdoor premises, right?
In an outdoor resort, yes.
But the vast majority of your work involves human-created workplaces, right?
For the most part, yes.
And Mr. Parser, you are not a safety expert, right?
I'm not a certified safety expert. I never took that class and never got the official diploma. My work does overlap with that of a safety expert.
But your work does need to be distinguished from that of a safety expert, correct?
Yeah. Yes, they're not exactly the same.
And Mr. Parser, just to clarify, you perform less than 50% of professional level safety duties, right?
Yes, safety is a massive enterprise. It has many different fields and scopes, so I only perform a small portion of them.
And you are not a certified safety professional at all, right?
Certified? No. Again, I never took the official class, never got the diploma.
Mr. Parser, let's talk a little about the snow cannon allegedly involved in Mr. Coulshan's crash. You've never listened to the model of the snow cannon present on May 18th, 2019, right?
I never listened to that exact model though. I listened to a new model that was at the ski resort.
But you've never listened to the model present on May 18th, right?
No, I haven't.
You've also never observed the snow cannon as it was originally positioned on May 18th, right?
No.
And when you visited the washout feature, you did not test whether you could feel any precipitation from a snow cannon, right?
Again, no.
In fact, you didn't visit the Wonder Trail at all until the spring of 2021, 2 years after the accident had occurred, right?
That's correct. We had a pandemic squished in between.
All right, let's talk about how the stopping distance formula works for trails. The formula that you relied upon to come up with the stopping distance for this trail was taken from the American Association of State Highway and Transportation Officials, right?
Yes, that's correct.
An organization that specifically sets standards for highway design, right?
Highways, roads, and other mediums of transportation.
Such as highway design and roads, right?
Yes, those are among the mediums of transportation that they set standards for.
You don't know what type of vehicle this formula was designed for, do you, Mr. Parser?
It was designed for a vast array of vehicles, not one specific vehicle.
You don't know what size vehicle this formula was designed for?
Again, it's specified for numerous vehicles, not one specific one.
But there aren't factors that go into that equation that account for the type of vehicle, are there?
Can you repeat the question, please?
There are not any specific factors that you change in the formula based on the vehicle you're looking at, right?
That's correct.
You also assumed a wet paved surface, not a rooted dirt surface like that of the Wonder Trail, correct?
Yes, in fact, a wet paved surface is likely made my calculations more generous than they should have been. I found a
Well,
stopping.
Mr. Parser, my question was specifically, you assumed a different surface than that of the Wonder Trail, right?
Yes, that's what the industry standard calls for.
You also arbitrarily assumed a speed of 15 miles per hour as Mr. Coulshan's initial speed, right?
That's incorrect.
You arbitrarily assumed the speed of 15 miles per hour to make your calculations on stopping distance, correct?
Yes, I assumed a speed of 50 miles an hour. However, my calculations don't specifically pertain to Mr. Coulshan.
So with this arbitrary speed, you also don't know the error rate for this formula, do you, Mr. Parser?
The error rate, I don't know the exact error rate, no.
No further questions, Your Honor.
Okay. Any redirect?
No, Your Honor.
Okay. Witness is excused. Does the plaintiff have any further witnesses?
No, Your Honor, the plaintiff rests.
Okay. Would the defense like a brief recess before we commence with its case?
Yes, Your Honor.
Okay. We'll be at recess for 5 minutes. Mr. Johnston, how are you doing?
Well, Commissioner Schmidt, I'm doing all right. How are you? It's nice to
just
see you.
fine. Good to see
Are
you.
Is that a real courtroom or a virtual courtroom?
It's virtual. I'm sitting at home.
Yeah, just like I'm sitting at home too, with my virtual temple back here. So, okay.
Well, at least we're starting to go back to hearing cases in the courtroom, at least some of them. So
Yeah, our court, it's going to be a while. We're gonna move to a facility in Tumwater for close to 2 years. So
that's right, during the remodel there.
During the giant remodel project. So we're getting ready for that, So anyway, tell everybody I said hi up there, okay?
I will.
All right.
We'll see you in a few.
See you later.
Okay, if the defense is ready, we'll go back into session. Defense may call its first witness.
Yes, Your Honor. The defense calls Parker Dockabed to the stand. Good evening. Please state your name and spell your last.
The name is Parker Dockabed. That is Dahkobed.
And what do you do for a living, Miss Dockabed?
I'm the proud Chief of Operations for Extreme Resort at Pato.
How did you become Chief of Operations?
Well, I've been working for Extreme Ski and Sport for years, and in 2011, I got presented with the chance to acquire Pato Ski Lodge. My job is basically my own because of the years I spent growing up there, when my dad was in the Army, of course.
And what are some of your responsibilities as Chief of Operations?
Well, I oversee all the departments on the property, which include the slopes, as well as the trails we offer for off-season activities. Most importantly, I maintain the well-being of the resort and keep the experience of our visitors as absolute best. It's my favorite part of the job.
And how do you maintain the well-being of the resort?
Well, the first thing I did in my new position within the company was to improve the slopes and other skiing equipment. And on the trails, we added coverts and diversion devices when better trails were demanded.
And have you had any problems with these better trails?
Yes, in January of 2019, a washout occurred on the Wonder Trail.
And how did you react to this event?
Well, I took this matter extremely seriously. After all, the trail is one of the most used sections of the system. Besides, our visitors' satisfaction is my top priority, so I had to make sure the situation was addressed.
And how exactly did you address this event?
I addressed it with Chase Bale, who is the expert of the company, as well as Bernie Steppe, our maintenance manager.
And what did you learn from these two?
Well, I learned that many other trails in the area had similar drop-offs and gaps, and these were perfectly normal things to see and didn't need to be changed.
Did you take any other actions to address the Wonder Trail washout?
Of course, I visited the top section of the Wonder Trail frequently to monitor conditions. I could clearly see the drop-off right as I came around the last corner.
Let's back up a little. What exactly is the Wonder Trail used for?
Well, the Wonder Trail is multi-use, so it's used by mountain bikers, hikers, and horseback riders.
Were there any existing safety measures on the Wonder Trail?
Yeah, there were multiple signs at the Wonder Trail's access point.
Would you recognize these signs if shown to you today in court?
I would.
Your Honor, permission for the bailiff to share previously entered Exhibit 6?
Granted.
Do you recognize this document?
I do.
And what does this document depict?
These are 3 warning signs at the Wonder Trail's access point that I just mentioned.
What does the first sign show?
The first sign is a caution sign telling users to enjoy the trail at their own risk. So let's put it this way, just like not every pool has a lifeguard on hand, we don't have someone monitoring the people on the trails at all times. So we just have to remind the users to enjoy the trail at their own risk.
What does the second sign depict?
The second sign is just telling mountain bikers to yield to both hikers and horseback riders. Just because the Wonder Trail is multi-use, they have to yield to everyone else on the trail. So just like cars on the road have to yield to pedestrians, mountain bikers have to yield to everyone else on the trail.
Ms. Dockabed, what's the third sign show?
The third sign just reminds users that there may be difficult or even potentially dangerous terrain at any point ahead on the trail, so they just have to look out for that.
In the end, what did you decide to do with the washout?
Well, I mean, after consulting a Steppe and Bale, personally walking the section myself, and having existing signs already at the entry to the Wonder Trail, I decided to not add any additional warnings for the washout because, I mean, if we added a sign for every difficult part of the trail, we'd have one every 5 feet.
Thank you. The bailiff can stop screen sharing. Thanks. And was this the end of your dealings with the Wonder Trail washout?
No, unfortunately, the plaintiff crashed there in May of 2019.
And had the plaintiff been to Extreme before?
Yes, there are records of the plaintiff visiting in prior years, so it's not like he was unfamiliar with our resort.
How did Extreme's medical team respond to Colshan's crash?
Well, even though the accident was unexpected, our on-site rescue unit with trained medical personnel was able to respond very quickly as soon as they received word of Colshan's crash.
I see. What steps must one take to ride the Wonder Trail?
Well, before using any of Extreme's trails, a user must obtain a parking permit, and they do this by agreeing to the resort's terms and conditions, then paying the fee that comes with it.
Would you recognize these terms and conditions if shown to you today in court?
I would.
Your Honor, permission for the bailiff to share Exhibit 5.
Granted.
Do you recognize this document?
Yes, I do.
What does this document show?
These are the terms and conditions from our resort's website.
And how do you know these are those same terms and conditions?
These are I'm very familiar with the obviously, as I'm the chief of operations, I'm very familiar with also what's on my website.
Thank you. Your Honor, I move to enter this exhibit into evidence.
Any objection?
No objections, Your Honor.
Exhibit 5 is admitted.
Ms. Dockabed, what does this exhibit specifically show?
Well, this exhibit includes all the terms and conditions that Extreme Pass Resort has, and most importantly, it includes number 13.
Could the bailiff screen please scroll down to number 13? Awesome, thank you. What does number 13 say?
Well, it states that it's the visitor's responsibility to be aware of any and all resort functions, like trail maintenance, ski slope grooming, and snow production, like the firing of snow cannons.
And Ms. Dockabed, did Mr. Kolshin even agree to these terms and conditions?
Yes, he did. A user can't have access to the trail without a parking permit, and you can't receive said parking permit without clicking I agree to the terms and conditions.
Thank you. No further questions, Your Honor.
Cross-examination?
Yes, Your Honor. Good evening, Ms. Dockabed.
Good evening.
Now, before we begin, I'd like to clear a few things up. First of all, the culverts and bridges on the Wonder Trail, they've been there since the Great Depression, haven't they?
Yes, they have. There wasn't any need to reconfigure the trails very much, especially because it's heavily advised against because it's bad for the environment.
All right, so we can agree that you did not add any new culverts, that's right?
I didn't add very many new culverts, but I did add a few, yes.
It's your testimony that you added a few new culverts?
Like I said earlier, we added culverts and diversion devices when better trails were demanded.
All right, Ms. Dockabed. Also, we can agree that when the plaintiff visited the Wonder Trail, the washout had yet to occur.
Excuse me, sorry, could you repeat the question?
Yes, of course. You mentioned that the plaintiff visited in past years.
Oh, yes.
So that would be before the washout occurred?
Yes.
And finally, you said on direct that in order to use the Wonder Trail, guests must purchase a parking permit?
Yeah, guests have to purchase a parking permit so then they can have access to the trail, yeah.
So we can agree that in order to use the trail, guests must pay a fee?
Yes.
All right. Now, Ms. Dockabed, I'd like to talk a bit more about the Wonder Trail. We can agree that there is a hole on the Wonder Trails, isn't that right?
Yes, there is a washout in the Wonder Trail.
And in your own words, this is a latent hazard.
Yes, it is a latent hazard.
Objection, hearsay.
Respond.
Your Honor, this is the witness's own words, submission by a party opponent.
Objection overruled.
So is that a yes?
Yes. Yes.
And now let's talk about how this hole or washout was created. There is a culvert under the Wonder Trail, correct?
Yes.
And culverts are large pipes that divert water underground?
That's true, yes.
Now, in January 2019, the culvert under the Wonder Trail failed, isn't that right?
Yeah, unfortunately, yes.
And this failure caused a part of the Wonder Trail to wash out, is that right?
Yes.
And this washout is the hole where Nikki Kolshin got hurt.
Yeah, that's true.
And now I'd like to talk a bit about development at Extreme Resort. Back when Extreme acquired Pato Resort, you were excited about developing it, weren't you?
I was very excited.
Now, currently, Extreme Resort is mostly a winter sport resort. Is that right?
Yeah, it's very attractive for the ski slopes. That's the main attraction, yes.
But you'd like to attract more warm season users, isn't that correct?
Yeah, I want our visitors to have enjoyment for the whole year. I mean, it's like my top priority. I want our visitors to have the best experience possible.
And we can agree that mountain bikers are mostly warm season users.
Yes.
So we can agree that you would like to attract more mountain bikers.
Yeah, I would like to attract more visitors in general because I want our visitors to have the best experience at our resort.
All right, Ms. Stackabed, I'd now like to talk about what happened after the washout. In your own words, Extreme could have fixed the hole for minimal cost.
Yes, but still, it wasn't very necessary because users should be looking out for any dangerous terrain, potentially dangerous terrain.
I'm not asking about your reasons for not fixing the hole. I'm just asking if it could have been done for minimal cost, and it could have, couldn't it?
Yes.
Extreme could have fixed the hole in about a week.
That's true.
But you decided against fixing the hole, didn't you?
I did. I didn't think it was necessary.
Now, fixing a portion of the hole, or fixing the hole would have required a portion of the Wonder Trail to be dry. Is that right?
Yes.
It would have had to be dry for about a month and a half or 6 weeks.
Yeah.
Now, the washout occurred in January. Is that correct?
Yes, that's when it occurred.
And we can agree that the Wonder Trail was not dry in January.
It was not, no.
And we can agree that in Washington, typically the weather doesn't dry up until about springtime. Is that about right?
Yes.
So to fix the trail, you would have had to close it from January to spring.
Yeah.
Now, the Wonder Trail is the resort's most popular trail.
Mm-hmm.
Popular with mountain bikers.
Very popular, yes.
It's popular with Happy Trails Adventure Company, which does horse tours.
Yes.
And you wanted to keep the hole open for as many customers as possible, didn't you?
I did, yeah.
Ms. Stackabed, after inspecting the hole, you didn't close the trail, did you? Did you hear my question? Ms.
That
Stackabed?
should be better. I'm sorry.
That's all right. Ms. Stackabed, after inspecting the hole, you didn't close the trail, did you?
I did not know.
You didn't close the trail in January.
I didn't close it in January.
You didn't close the trail in February.
Objection to relevance.
Response.
Your Honor, today's case is about whether Extreme Resort was negligent in their maintenance of the hole and whether that negligence led to Mr. Colshan getting injured. Them not closing the hole for whatever reasons does directly go to them being negligent and not properly caring for the hole or properly repairing the hole and therefore allowing their customers to get injured.
Your Honor, may I respond?
You may.
The specific months that the trail was or was not open is not relevant in this case to whether or not it was negligently operated at the time that Colshan crashed, which was during the month of May. Therefore, running through each of these months prior hand, it really isn't relevant to the case at hand.
Respond.
Okay, I'm going to overrule the objection since it's on cross-examination. You may continue, counsel.
All right, I'll start at, you didn't close the trail in March.
No, I didn't.
And you did not close the trail in April.
I didn't either.
Finally, Ms. Stackabed, I'd like to talk about the signage at Extreme Resort. We looked at the signs that are at the head of the Wonder Trail on direct examination. Is that right?
Yes, we did.
And we can agree that these signs existed before the washout occurred.
Yes, they did.
We can agree that after the washout occurred, these signs were not changed.
No, they weren't.
Now, these signs were not changed, even though Valhalla suggested adding new ones.
Yeah, users should already be looking out for any potentially dangerous situations that could happen on the trail. So I didn't feel like there was a need to add more signs.
I'm not asking about your rationale. I'm asking if Valhalla suggested adding new signs. And he did, didn't he?
Yes, he did.
Valhalla is your company's safety expert, isn't that right?
Yes, he was.
So in not adding new signs, you were going against your own safety expert.
Yes, but I...
Hearsay. May I elaborate?
You may.
Your Honor, this question is based off of hearsay testimony that Mr. Holla would have given to Ms. Dockabed. While Mr. Holla did testify as this testimony as to this these suggestions in court, it cannot be assumed that Ms. Dockabed actually heard them that way or interpreted them that way. Therefore, this stays hearsay.
May I respond? Your Honor, this is admissible under 801 D2D.
Okay, I'm going to overrule the objection.
All right, may I re-ask the question?
You may.
Ms. Dockabed, in not adding new signs, you were going against your own safety expert. Is that correct?
Yes, but I do have a higher position than him.
Thank you. No further questions.
Any redirect?
Yes, Your Honor. Ms. Holla, Ms. Dockabed, is it Mr. Holla's job to determine who the popularity of the Wonder Trail?
Objection outside the scope of the cross.
Your Honor, may I respond?
Objection overruled. You may ask the question.
Ms. Dockabed, is it Mr. Holla's job to determine whether or not the Wonder Trail is popular enough to stay open?
No, it's his job to no, sorry.
Thank you. No further questions.
Any recross?
None, Your Honor.
Okay, thank you. The witness is excused. Defense may call its next witness.
Yes, Your Honor. The defense calls Bernie Estepe to the stand. Good evening. Please state your name and spell your last.
What's up? My name is Bernie Estepe. I shouldn't. Last name Isteppe.
And are you currently employed, Mr. Estepe?
Yeah, I got a job as the head of physical plant and operations at the Extreme Ski and Sport Resort on Mount Plateau.
And what are some of your responsibilities as head of physical plant and operations?
Well, I direct my boys on the maintenance of trails around the resort. Whenever my boss, Parker, wants a new thing added on, or anything that's needed to be fixed, I'm there because that's part of the job. I've also been trained in the art of snow manufacturing and the operation of the snow cannons.
And what does the manufacturing of snow entail at Extreme?
Well, to put it in simple terms, I just get up, go to the cannon, turn it on, sit back, and watch the show. Simple, really. Pretty good for 75 grand a year.
Okay, and would you consider yourself knowledgeable on the operation of snow cannons?
Is that really a question? Of course I am.
And would you recognize a snow cannon if shown to you today in court?
Yes, I would.
Your Honor, permission for the bailiff to screen share Exhibit 4?
Granted.
Do you recognize this picture?
Yes, I do recognize it.
What is this a picture of?
Well, it's the picture of the snow cannon.
And how do you know this is the same snow cannon that you regularly operate?
Well, I've been working with the snow cannon for 5 years, and at this point, I've been with this snow cannon longer than my first and third wives combined. Was I supposed to say that? Oh, sorry.
Thank you, Mr. Estepe. Your Honor, permission to enter this exhibit into evidence?
Any objection?
No objection, Your Honor.
Exhibit 4 is admitted.
Mr. Estepe, did you fire the snow cannon on May 18th?
Yes, I did.
And why did you fire this snow cannon?
Well, you know, during the spring, the days get longer, temperatures get warmer. So I was trying to lay down a layer of snow for the folks coming up the mountain later in the day.
And did you check the ski slope before firing the snow cannon?
Of course I did. It's part of the job. There's a person uphill away, but they had stopped. And since there's nobody on the leg, I decided it was safe to fire.
And did you check the Wonder Trail before firing the snow cannon?
No, I did not.
But would you recognize a picture of the Wonder Trail if shown to you today in court?
Yes, I would.
Your Honor, permission for the bailiff to screen share Exhibit 2?
Granted.
Thank you. Mr. Estepe, do you recognize this?
Yes, I do. It's a picture of the Wonder Trail.
And how do you know that this is a picture of the Wonder Trail?
Well, I've been working in this area for about 30 years, and so I know this is the Wonder Trail. There's the bend around the cliff face, and the dog's leg is over the cliff to the left. From this angle.
Your Honor, permission to enter this exhibit into evidence?
I believe it was already admitted into evidence, but if it wasn't, it's admitted.
Thank you, Your Honor. Mr. Estepe, why didn't you check the Wonder Trail before firing the snow cannon?
Well, from my perspective, operating the snow cannon, I can't really see over the cliff as it's pretty steep, but that also means that no snow or ice will really hit the riders on the trail.
And do you know why? Do you personally know why no snow or ice has ever hit a rider before?
Well, like I said, there's the pretty steep cliff between.
Objection, Your Honor. That's speculation.
Objection overruled. It goes to the knowledge of the witness.
Mr. Estepe, would you like to continue?
No, it's fine. I can continue. Like I said, the pretty steep cliff in between the snow cannon and the trail will kind of block the ice or snow that will in essence hit the trail. So that is why we don't really have problems with snow or ice hitting riders.
And from what you've personally observed, does this cliff affect the riding of any of the bikers?
Well,
objection, Your Honor, that's speculation.
Your Honor, may I
Mr. Steppe
respond?
talked about how the cliff or the Wonder Trail would have affected riders' experience.
Your Honor, may I respond?
You may.
Your Honor, Mr. Estepe, as he is established, has been working here for 30 years. He knows, he has seen how bikers usually bike on straightaways on the trail, and he has seen how they bike around the bend in the trail. He is simply saying that he is simply testifying as to how they bike around the cliff side.
May be heard, Your Honor.
You may.
In this specific instance, opposing counsel is asking Mr. Steppe to speculate on the rider's experience while going on the trail, not just simply about what he saw.
Okay, I'm going to sustain the objection, but allow you to rephrase it regarding what this witness has seen.
Mr. Estepe, what have you seen riders do as they ride around this cliff face?
Well, I've seen riders either be speeding on the trail or riding with caution, as that's what the trail signs at the trailhead had recommended.
And what might some of these riders have been speeding up to?
You see, in January 2019, we had a flash flood, and that washed out parts of the Wonder
Objection, Your
Trail.
Honor. This is based on speculation. Opposing counsel just asked Mr. Steppe to speculate as to why the riders may have been speeding up.
I think the witness was trying to begin his answer. I'm going to overrule the objection at this point.
Would you like to continue, Mr. Estepe?
Yeah, sure. You see, the washout, there's a flash flood and that washed out parts of the Wonder Trail, and that created the hole, which bikers...
And as head of physical plant operations, what did you do to fix the hole, if anything?
So I brought it up with my boss, Parker Dockerbed, and told her that the culvert could be reinserted, and most of the drop could be eliminated after the ski season. But Parker decided to keep it to make the trail a little more extreme, as after all, the company is called Extreme Ski and Sport Resort.
I see. And did you take any other actions as it relates to the Wonder Trail washout?
Well, I was instructed by the company to barricade the entrance to the trail, but every morning I would come back to see that the barricades had been knocked over. So I had to keep going back and putting the boards over and over again. Real talk, I don't see why the company had put the boards there in the first place. If the riders got hurt, it wouldn't be our fault. It'd be their fault.
Thank you, Mr.
Your Honor.
Steppe.
Objection, Your Honor, to the witness's last portion of the witness's answer about whether or not the biker's injuries would have been Extreme's fault. That goes to the exact point of today's case, which is determining liability.
Your Honor, may I respond?
You may.
Your Honor, the witness was not testifying as to Mr. Colshan's fault, for Mr. Colshan didn't break down the barricades or anything. He is stating that after Mr. Colshan's crash, after the trail was shut down, the people who then broke in Mr. Estepe's personal opinion, it would have been their fault if they crashed while the trail was shut down.
Okay, I'm going to strike the last comment of the witness regarding fault, because the ultimate question in the case.
Yes, Your Honor. No further questions.
Okay. Cross-examination?
Yes, Your Honor. Good evening, Mr. Estepe.
Good evening, ma'am.
Now, before I go into the events of today's case, I want to clarify a few things. Now, you are the head of physical plant and operations for Extreme.
Yes, that's my job.
As part of your job, you oversee maintenance of the trails at Extreme.
That's part of the job. Mhm.
And one of those trails is the Wonder Trail.
Yes, of the many trails in the resort.
All right, now I want to talk about the Wonder Trail, in particular the hole on the Wonder Trail. Now, like you said on direct, you knew about the hole on the Wonder Trail.
Yes, I did know about it, as I oversee the maintenance of the trails.
And you learned about this hole shortly after it occurred.
Yes,
You even went to examine the hole yourself.
that's what I did. And in the aftermath, as that's also part of my job.
And you would recognize a picture of the hole if I showed it to you today.
Yes, I would.
Would my co-counsel now please screen share Exhibit 3? Now, Mr. Estepe, this is the hole on the Wonder Trail.
This is an accurate image, yes.
Your Honor, the plaintiff offers Exhibit 3 into evidence.
Any objection?
No, Your Honor.
Okay, Exhibit 3 is admitted.
Now, like we just covered, Mr. Estepe, this is the hole on the Wonder Trail that we were referring to earlier.
That's correct.
And this hole is 20 feet wide.
A rough estimate of 20 feet wide.
This hole is invisible until you are right on it.
Well, when I examined it, it was probably, it was close to invisible.
When you examined it, you said this hole was invisible. Is that correct?
That is what I just said, correct?
You may take down the exhibit. All right, now I want to talk a little bit about how this hole was created. Now, Extreme had invested heavily into snowmaking equipment.
Yes, we did.
Objection, Your Honor. Lacks personal knowledge.
May I be heard, Your Honor?
You may.
Your Honor, on direct examination and during cross-examination, Mr. Estepe testified to knowing about the snow machines, and as head of physical plant and operations, he would know how Extreme put together the snow machine equipment.
Your Honor, may I respond?
Yes, you may.
Your Honor, opposing counsel's question seemed to go more to whether or not Extreme was diverting more resources to investing in more snow cannons, to which Mr. Estepe would not be knowledgeable in, seeing as he isn't in any of the accounting or finance or decision-making parts of the company.
Okay, I'm going to overrule the objection. Witness may answer.
Would you like me to ask that question again, Mr. Estepe?
Yes, please.
Now, Extreme had invested heavily into snowmaking equipment.
The company did, correct?
And this was on its ski runs?
Yes, as that's why the snow machines are there.
And one of those runs was the Dogs Lake ski run.
That is correct.
Now, the Dogs Lake ski run is uphill from the Wonder Trail.
Yes, there's the cliff between the Wonder Trail and the ski run.
And as part of installing snowmaking equipment, Extreme laid down electrical conduit.
Could you repeat the question? I didn't catch the end.
Yes, now as part of installing snowmaking equipment, Extreme laid down electrical conduit.
That is correct.
Extreme also laid down pipes.
Yes, that's what the culverts are for.
And these pipes delivered water up to the snow machines.
Yes, that's what they did.
And the snow produced from these snow machines is artificial.
Well, that's why the snow machines are there, to produce artificial snow. That's correct.
So they do produce artificial snow.
Yes, I just said that.
And when the artificial snow melts from the dog's leg, it flows downhill.
Yes, that's what happens.
and the water drains into the Roaring Gulch.
That is where the water gets deposited, correct?
Now, there's a culvert, a large drainage pipe under the Wonder Trail, or there was one,
Yes, there was one.
and water flowed through this culvert under the Wonder Trail.
That is where the snow melt would be running. Yes,
And this culvert is part of the Roaring Gulch.
that is correct.
And we can agree that the Roaring Gulch is a gully.
It is a gully. It would be considered one.
And like you said on direct examination, there was a flash flood in the gully.
Yes, there was.
And also, like you said on direct examination, this flash flood created the hole.
Yes, as
Objection, Your Honor, relevance.
Maybe heard, Your Honor.
Response?
Your Honor, this goes to whether or not the hole was artificial.
Your Honor, may I respond?
Briefly.
It's already been well established that the hole was artificially created.
Objection overruled.
Now, Mr. Steppe, this flash flood, which created the hole, took out 20 feet of the Wonder Trail.
well, I already mentioned that it did take out about 20 feet.
All right, now I want to talk about what happened in May. Now, you were operating the Dog's Leg snow machine on May 18th.
Yes, I was.
You were making snow in the afternoon.
That was one time. I was also making snow in the morning that day.
Well, I want to talk about when you were making snow in the afternoon. Now, when you were making snow, like you said on direct examination, you checked the slopes for skiers.
I did check.
And like you said on direct examination, you didn't check the Wonder Trail at all.
Well, it really isn't necessary to check if the snow cannons are meant to be making snow onto the slope and not onto the trail. Also, the cliff is blocking the snow from going onto the trail, so there really is no need to check the Wonder Trail.
But you didn't check the Wonder Trail for bikers, did you, Mr. Steppe?
No, I did not.
And you still started the snow machine.
Yes,
And this was Extreme's loudest snow machine.
yes, but all snow machines are pretty loud.
But this one was Extreme's loudest snow machine. Is that correct?
That is correct.
In fact, it was so loud, you need to wear ear protection.
Well, that is advice for all snow cannons, and especially for this one.
Especially for this one, because you wouldn't recommend standing within 30 feet without that ear protection.
That's what I had written recommended.
All right, now I want to backtrack to the hole we were talking about earlier and Extreme's decision to keep it. Now, like we just covered, Mr. Steppe, the trail was washed out in January.
Yes, it was.
And right after this happened and the hole was created, you talked to Mr. Akabed and Mr. Holla.
I did talk to them.
And their response was to block off access to both trailheads for a week.
Yeah, so we could see what was going to happen to the trail.
And once this trail was blocked off, you inspected the hole.
During that time, that's when I did inspect the hole, correct?
You then told Ms. Akabed that the hole could be fixed.
That was my assessment.
Your assessment was that the hole could be fixed.
Yes.
But Ms. Akabed told you to leave things as they were.
Well, my boss, Parker, she makes better. She is my superior, so she often makes decisions.
But regardless of your insistence that the hole could be fixed, Ms. Akabed.
Your Honor, hearsay. Hearsay to the part of, despite your insistence that the hole could be fixed.
Overruled.
I'll ask that again, Mr. Steppe. Now, despite your insistence to fix the hole, Ms. Akabed told you to leave things as they were. Is that correct?
That is what happened.
Now, the accident of Mr. Colshon happened in May.
That is when it took place.
And the hole was artificially created in January.
I already mentioned that it was created in January.
So the hole remained on the trail for 4 months. Is that correct?
Yes, but there really is no incentive to fix the trail when there aren't any injuries. So there's no need to fix the trail. So we did not fix the trail for the 4 months in between the creation of the hole and the accident.
Mr. Steppe, the hole was there for 4 months. Is that correct?
Objection, asked and answered.
Overruled.
I'll ask that one more time, Mr. Ostepi. The hole was there for 4 months. Is that correct?
Yes, it was there for 4 months.
Thank you, Your Honor. No further questions.
Any redirect?
No, Your Honor.
Okay. Then this witness is excused. Defense may call its next witness.
The defense would like to call Dakota Booker to the stand next. Please state your name for the record.
My name's Dakota Booker. That's spelled Booker.
And what do you do for a living, Miss Booker?
I run 2 horseback riding companies.
Why do you work with horses?
Well, I grew up with them and I've always loved working with them. So that's why I created my horseback riding company, along with my other businesses.
What are these other businesses?
Well, one is the High Alpine Adventures that kind of provides customers with more adventurous experiences. The one I focus more on, though, is called the Happy Trails.
Can you tell us a little bit more about Happy Trails?
Well, I bought the Happy Trails. It came with a contract to provide our services exclusively through Extremeland. And while some customers like to book their rides through Extreme, a majority have ended up booking through Happy Trails.
How has your business relationship been with Extreme?
So we had a pretty good relationship. They provided our trails. They provided trails for all our horse rides to take place on, one of which was the Wonder Trail. Now, the thing with trails is, of course, there's going to be a little bit of wear and tear over the years. So occasionally I notified Extreme about some deteriorating condition of some of the trails, but I mean, I didn't expect them to cover absolutely everything. So.
And let's talk some more about the Wonder Trail you just mentioned. What made this Wonder Trail so unique?
Well, okay, part of its uniqueness is how the trail is multi-use. So mountain bikers and horse riders share it, which is why it's kind of really important to follow the rules. One of the rules is that mountain bikers are supposed to yield to riders, which is clearly detailed in the signs at the top of the Wonder Trail. But I mean, fortunately, not everyone bothers to really follow these universal rules.
What do you mean by that?
Well, there's many mountain bikers I've encountered on the trails. They'd come flying around corners, shooting off jumps, just all sorts of crazy antics, like a bunch of squirrels.
And what was the worst experience you ever had with a mountain biker?
Well, I'd say my encounter with Nikki Colshan on May 18th, 2019. That ranks pretty high on the list.
Could you describe your encounter with Nikki Colshan?
Yeah, out of nowhere, Nikki Colshan flew by us, spooking the horses I was with to the point where my most experienced horse, Ed, reared up uncharacteristically. And something crazy has happened when my Eddie is spooked. That doesn't just happen.
And what happened after that?
Well, after bolting past us, Colshan made some sort of hand signal to me, taking their hand off the handlebar while zooming down the trail. Even after Colshan was gone, my horses still needed some time to calm down.
And how did Colshan compare to other mountain bikers that you've seen?
Even as a horse trainer, I know it'd be unsafe to take your hands off the handlebars, and none of the other riders I've really encountered have done anything like that. So I don't know, it was unsettling to say the least.
And what did you make of the horses' reactions to Colshan?
Well, some of the horses that were there with us weren't completely broken. The one I was on, old Ed, he's a champ. He's been with me for literally forever, and he has the mind of steel. So to spook Eddie the way that Colshan spooked him, something crazy had to have happened.
And what led you to believe this?
Opinion. May I be heard, Your Honor?
You may.
Your Honor, the witness's testimony as to Nikki Colshan doing something crazy invades the province of the jury. They're here to decide and to characterize Nikki Colshan's actions. Therefore, Ms. Booker's characterization of Nikki Colshan's actions as crazy is improper.
Response?
Your Honor, this is not improper, as the witness is testifying to her horse's reactions being uncharacteristically. As she said, this happened as Nikki Colshan passed by, as she was able to deduct that this was because of Nikki Colshan doing something uncharacteristically.
May I be heard, Your Honor?
You may briefly.
Although I agree that the witness can testify to her perception of what Colshan did, excessive testimony about how she characterized Colshan's actions does indeed invade the province of the jury and is improper.
Objection overruled.
And what led you to believe this?
Well, with all the different terrains on the trail, my horses really love it and they're experienced with it. So they've learned to adapt to all the things that happen here. There's loud parties, there's low flying military planes, and there's risky turns on the trail.
Thank you. No further questions, Your Honor.
Cross-examination.
Yes, Your Honor. Good evening, Ms. Booker. I'd like to begin by talking about where you were after you went up some switchbacks on the trail. Now, after you went up these switchbacks that were on the trail, you were back in a curve, correct?
Yeah, that's true.
This was the curve right next to the hole.
Yeah, I was there.
And just to clarify, in this curve right next to the hole, there were no signs mentioning the hole, were there?
I mean, not that I'm aware, but I mean, the hole was right there in front of us, so it was pretty visible.
Right, but there were no signs on that blind corner?
I don't believe there were.
Now let's talk about something else that happened in that curve right next to the trail. This was where Mr. Colshan passed you, is that right?
Oh my God, yeah. Yeah, he was there.
And right after Mr. Colshan passed you, a snow cannon went off, is that right?
Yeah, there was right after.
And these snow cannons, the noise they produce, it's sudden, isn't it?
I mean, like usually my horses don't really react to it, but like it's a little annoying. At worst, it's like a little spritz of water, but yeah.
So we can agree the sound is sudden?
I mean, there's lots of loud noises along the trail, but you could include that as part of it.
And as you just said, the noise produced by these snow cannons is quite loud.
Yeah, it's pretty loud, but again, there's a lot of different disturbances on the trail anyway, so it's not out of the ordinary.
Well, Ms. Booker, you compared the noise of these snow cannons to a monster truck rally, is that right?
Yeah, I did. Because, I mean, it's loud, but like nothing too crazy.
But you did compare it to a monster truck rally.
I did, yeah.
Right, now let's talk about the hole in the Wonder Trail, Ms. Booker. Now, you and your horses frequently have to work your way around the hole, is that right?
I mean, yeah. I mean, some of my horses aren't really adventurous enough to really go by it. Plus, it's not too realistic for them to go by it. But like a lot of my other horses do love a little bit of adventure. So yeah, we avoid usually that. It depends on the horse.
Regardless of your horses, Ms. Booker, you thought the hole was unsafe, is that correct?
I mean, for a horse rider, yeah. I don't know about mountain bikers. They do whatever they want. But
right, but we can agree that you thought it was unsafe.
Personally, I would never do that. Yeah.
Okay, and so you complained to Extreme Sports multiple times.
I mean, yeah, like I brought it up a couple of times, but I mean, it's impossible for them to fix every little thing on the trail. So I wasn't expecting complete change on it.
Ms. Booker, I'm not asking about what Extreme Sports can and can't repair, but let's clarify something. You told Ms. Jacobed that the hole should be fixed, is that right?
At some point, I made some comments, yeah.
Well, Ms. Jacobed, she told you that the hole enhanced the thrill index of the resort. Is that correct?
Yeah, she did say that.
Objection hearsay.
May I be heard, Your Honor?
Great. Yes, you may.
This testimony by Ms. Parker Jacobed is admissible under two prongs. First, I'm not offering it for the truth of the matter that the hole actually raised the thrill index. It's also admissible under 801 D2D as a speaking agent.
May I respond?
You may.
Your Honor, hearsay is an out-of-court statement offered in evidence to prove the truth of the matter, as Rule 801C states. And the counsel here used the state of the matter of what she said by saying that that Jacobed said certain things, and that is why Booker interpreted it the way she did. Meaning that would be an out-of-court statement used for the truth of the matter.
Okay, I'm gonna sustain the objection to hearsay.
Thank you, Your Honor. No further questions.
Any redirect?
Yes, Your Honor. Now just one question. Did the loud sudden snow cannon go off before or after the horse Ed reared up?
pretty sure it was after.
Thank you. No further questions.
Any recross?
No recross, Your Honor.
Okay, thank you. The witness is excused. Defense may call its next witness.
Before we start, can we ask the bailiff how much time is left for defense's direct? Okay, thank you. The defense would like to call Professor Grom Atherton to the stand. Good afternoon, Professor. Please state your name for the court and spell your last.
Good evening. My name is Grom Atherton. That's Atherton.
What do you do for a living, Professor?
Well, I'm a professor in philosophy and psychology at Existential Sciences University, an online school, funny enough, so I'm used to online settings. I lecture on subjects like safety, ethical mountain biking, and multi-use etiquette.
How long have you been teaching?
Well, I've been teaching at EXU since 2010, but I started teaching after getting my doctorate in philosophy and my JD at the University of Idaho School of Law.
And what exactly is psychology?
Psychology is the ethics and practices of biking.
What qualifies you to teach psychology?
Well, I've been biking since I could walk, but professionally speaking, I am the president of the International Mountain Biking Board, and I was the past chair of the USCB, or United States Committee on Biking Practices and Standards, where we often review and refine the rules of the trail.
Were you provided any material to review before today's trial?
Yes, I did. To form my expert opinion on whether Mr. Kolshan as a biker, fulfilled the standards of care, I have been given exhibits and affidavits to form my opinion.
Were these standards of care available to mountain bikers like Mr. Kolshan?
Well, these standards should have been known to even the most casual mountain biker. If Mr. Kolshan had purchased a bike after 1998, he would have been sent a copy of the standards of care attached to the frame of his bike. He also showed that he knew the rules by repeatedly retweeting the links of the rules, signing Extreme's terms and conditions, and choosing to ride a mountain bike at all.
Have you seen Extreme's terms and conditions before?
I have. It was one of the documents that I got to review.
Would you recognize a copy of this document if shown to you in court today?
Absolutely.
Your Honor, permission for the bailiff to screen share what has previously been admitted as evidence number 5.
Granted.
Do you recognize this document, Professor?
I do. It looks the same as the one I reviewed.
How would a reasonably careful user handle these terms and conditions?
Well, they would have at least skimmed over the entire document, so they know all the facts of the conditions.
And how are these terms and conditions related to the standards of care for mountain biking?
Well, the rules reference that all riders under rule number 4 should know the USCB standards of care, as well as the Your Responsibility Code under rule number 9.
And what were the most relevant standards of care to this case?
Mountain bikers should always yield to non-bike trail users. Mountain bikers should always scope out terrain features before riding them. And mountain bikers should always ride in complete control.
Let's talk about that first standard. Did Extreme acknowledge the guidelines surrounding yielding?
Yes, they did. They even had signs posted up to remind riders of this rule, but they're completely unnecessary for anyone who knows the standards of care.
So did Mr. Kolshan yield appropriately on May 18th, 2019?
No, he failed to yield to 2 hikers, but more importantly, a horse. The only thing keeping an animal safe from you is you. The animal is always right.
How should mountain bikers yield to horseback riders?
Well, especially since the Wonder Trail is kind of curvy, the first step would be to stop the bike. The second step would be to move off to the side to give the horse enough room to breathe. The third step would be to wait for the horse to pass. Following any other procedure should be up solely to the horseback rider.
And what did Mr. Coolshan do?
As he approached the horses, he sped past them without stopping.
Let's talk about that second standard of care. How can mountain bikers scope out a trail?
Ideally, they would walk the trail before attempting their first ride, or they would ride extremely slowly and cautiously.
Professor, why is it important to follow this standard of care?
Well, mountain biking is different from street biking because trails are purposely made to be difficult and exciting. So shadows, rocks, or even holes are only problems if a rider is not riding in complete control.
That brings us to the third standard of care. What exactly does it mean to ride in control?
Riding in control means that a biker must ride in a speed and style, that they are in complete control of their body and mind. Speeding, reckless riding, and inattentiveness are the primary causes of injury to riders and those around them. Conduct like moving too fast to see upcoming terrain features, or not stopping or slowing down to wait for your eyes to adjust to lighting, like Mr. Coolshan did, that kind of conduct is just inexcusable.
Did Extreme warn users about these terrain features?
They did. They explicitly stated under Rule 21, I think.
If the bailiff could scroll down to Rule 21.
Yes. They went out of their way to list the possible risks, including variations in steepness of terrain, surface and subsurface conditions, and terrain features.
Professor, what did Mr. Coolshan indicate when he signed Extreme's terms and conditions?
Mr. Coolshan indicated that he was aware of the risk associated with mountain biking, and I quote, use Extreme's terrain at their own risk, and freely and expressively assume any and all risk of injury associated with these activities under Rule 21.
And did the terms and conditions mention the resort's accountability?
Signing meant agreeing to not hold the resort accountable for any claims, including negligence, as from causes of mountain biking.
The bailiff can stop screen sharing the exhibit. Professor, in your expert opinion, did the plaintiff, Nikki Coolshan, uphold his standards of care as a mountain biker?
No, Mr. Coolshan did not uphold the standards of care, risking the safety of himself and all those around him.
No further questions, Your Honor.
Cross-examination?
Yes, Your Honor. Before I begin, may I inquire how much time is left for cross-examination? Your Honor, pursuant to Evidence Rule 2.08, if we are left with less than 2 minutes for cross-examination, we are granted at least 2 minutes for cross-examination. Is that all right?
You have your 2 minutes, yes.
Thank you. Good evening, Ms. Atherton.
That's Professor Atherton.
Excuse me. Good evening, Professor Atherton.
Good
now,
evening.
you reviewed the exhibits in today's case, is that right?
Yes, also affidavits.
Your Honor, permission to screen share what has been previously admitted as Exhibit 2.
Granted.
And Ms. Atherton, Exhibit 2 is the approach to the hole, is that right?
Yes, it is from my knowledge.
It's the approach to the hole in the direction my client was riding.
Yes.
So this was the view Mr. Coolshan saw just before he fell into the hole.
Yes, I assume so.
Now, after your review of this exhibit, Ms. Atherton, you came to the conclusion that the approach to the hole is deceptive. Is that right?
I mean, trails are deliberately built to be deceptive. That's why it's so important to follow that second rule, scoping out terrain features before riding them. So deceptive curves like these aren't a problem. But yes, it is deceptive.
So we can agree, Ms. Atherton, that you thought that the hole would have been difficult to see.
Yes, as I just stated, I did express that this is a little bit deceptive because you can't see the hole. But scoping out the terrain features, this wouldn't have been a problem.
But we can agree, Ms. Atherton, regardless of whether or not would have been a problem, you thought that the hole was difficult to see. Is that right?
Yeah, I thought it was difficult to see.
Thank you. No further questions.
Any redirect?
Yes, Your Honor. If the hole was difficult to see, why would this have been or not been a problem for a responsible rider?
Well, a responsible rider would follow the standards of care and scope out terrain features before riding on them, so that deceptive things like these are not a problem. Because, as I stated before, mountain biking is different from street biking. If a rider wanted a nice, easy trail to ride on, they would have gone on the roads, riding fast with cars. But they chose mountain biking because those have technical features. So mountain biking needs to have scoping of trails. That's why it's so important.
No further questions, Your Honor.
Any recross?
No, Your Honor.
Okay. Thank you. The witness is excused. Does the defense have any further witnesses?
No, Your Honor. The defense rests.
Okay. I believe there was a request made for a 2-minute recess before closing arguments, so we'll be at recess for 2 minutes.
Your Honor, I'm ready to proceed whenever.
Okay. We'll proceed to closing arguments. The plaintiff may begin whenever they're ready.
Ladies and gentlemen of the jury, today you got to know Extreme Ski and Sport, a well-named company. A company that goes to extremes when it comes to making money or attracting new business. A company that will even go so far as to manufacture snow in late May to keep their customers coming in. You also got to meet my client, Mr. Kulshin, an outdoorsman and entrepreneur who loves the sport of mountain biking. You heard about Mr. Kulshin's tragic injuries which occurred because extreme sports prioritized living up to its name. The hole hidden in the middle of the Wonder Trail, the hole where my client got hurt, was a hazard. A hazard extreme sports chose to ignore because they knew that repairing the hole would mean they would close their most popular trail for months. Again, Extreme Sports is a well-named company. Today, the plaintiff has the burden of proving by a preponderance of the evidence that Extreme Sports was negligent, and that this negligence was the legal cause of Mr. Kulshin's injuries. Meaning, if it weren't for Extreme Sports' negligence, Mr. Kulshin would not have been injured. We have met our burden. So how was Extreme Sports negligent? Well, under jury instruction 8, negligence is defined as the failure to exercise ordinary care. As a corporation, Extreme Sports had a duty. It had a duty to protect its customers from harm on its facilities. In today's case, we've seen that Extreme breached its duty of care when the officers and employees failed to exercise ordinary care. An ordinary reasonable person would repair a dangerous hole in the middle of a trail, or at a minimum, warn about it. An ordinary reasonable person would check for mountain bikers or horses in the vicinity before turning on a deafening machine, a machine which produces a noise that would startle anyone who didn't know the noise was coming. Now, Extreme Sports, it failed to do any of these things. But before we talk about these failures, let's be clear on why the hole was so dangerous. Members of the jury, the hole was a hidden hazard. Here in Exhibit 3, we can see that the hole was a hazard. It's a massive 20-foot hole in the middle of a trail, a hole that's located right below the loudest snow machine on the mountain that is turned on without checking for mountain bikers below first. Here in Exhibit 2, we can see that the hole was hidden. The hole is located right after this blind corner. No one coming around this curve can know the hole is coming. But what's seen in these photos was confirmed by the defense witnesses. Dakota Booker told you the hole was massive. Bernie Estepi told you that the hole is invisible until you're right on it. The defense's expert told you that you can't see the hole coming. And in Parker Dacabed's own words, the hole was a latent hazard. Extreme Sports is a well-named company. They had 4 months to act reasonably. 4 months to make a repair. They didn't. 4 months to listen to their own risk manager who was urging them to put up a sign. Again, they didn't. What they did was make the conscious choice to not repair the hole because, as you heard today, Parker Dacabed cared more about being extreme. What they did was make the conscious choice to not warn about the hole, even though, as our expert told you today, their signage was ineffective. It was too general, too far from the hazard, and would not stand out to any mountain biker on the trail. Now, the defense may try to call into question the testimony or the credibility of our expert. But members of the jury take into consideration that the defense counsel spent more than half of their cross-examination asking about sight stopping distance, something which we aren't even arguing today. Also, members of the jury, Ms. Dacabed, she took you through those signs. She tried to tell you that they were adequate enough to warn. But take into consideration, those signs were put up before the hole was created. They weren't intended to warn about a 20-foot hole hidden in the middle of a trail. Extreme Sports could have put up one single sign to warn about the hole. But instead, Extreme Sports chose to live up to its name. Extreme Sports breached its duty of care and left a latent hazard in the middle of a trail with no warning. It was inevitable that someone was going to get hurt. Members of the jury, it could have been any of us. It just so happened that it was Mr. Kolshin. Today, you have the responsibility of finding justice for Mr. Kolshin. Don't let the fault fall on Mr. Kolshin for Extreme Sports' irresponsible actions. Extreme Sports is a well-named company. They could have chosen to be both extreme and responsible. They only chose one. Members of the jury, find Extreme Sports liable. Thank you.
Thank you, counsel. Closing arguments from the defense.
Yes, Your Honor. On May 18th, 2019, fans goaded YouTuber Nikki Kolshin into recklessly barreling down Extreme Ski and Sports Wonder Trail. The plaintiff chose to abandon caution, chose to spin faster and faster until he spun out of control. Now Mr. Kolshin is trying to divert the blame for his subsequent fall from fame. The plaintiff accuses Extreme of causing his injuries by failing to maintain the Wonder Trail and operate snow manufacturing equipment in a reasonably careful manner. However, today we have seen it that it was Mr. Kolshen who demonstrated extreme negligence and extreme greed. The defense has demonstrated far beyond preponderance of evidence that it was Extreme who went above and beyond in its responsibility to operate the resort. Further, Mr. Kolshen assumed the risk of his actions and demonstrated contrary negligence that ultimately caused his injuries. Now let's backpedal for a minute. What really happened on May 18th? Testimony from Mr. Kolshen, plaintiff's eyewitnesses Jean Von Tromba, and defense eyewitnesses Dakota Booker corroborate the following. Facing immense pressure from his fan base to create riskier and riskier videos, the plaintiff purposefully chose to ride a challenging trail. Out of shape, out of practice, and almost out of daylight. Mr. Kolshen chose to perform tricks and accelerate down the trail far faster than any reasonable biker would have. This unexpectedly risky behavior caused Miss Booker's horse, a veteran of the Wonder Trail, to uncharacteristically rear up. Mr. Kolshen then raised an arm, taking a hand off his handlebar, and yelled at Miss Booker before accelerating to the washout. Then the snow gun fired. Before riding the Wonder Trail, Mr. Kolshen indicated that he had read and agreed to Extreme's terms and conditions, by which warned the risk of variations in steepness and terrain features on the trail. By signing this contract, Mr. Kolshen acknowledged and expressly assumed all risks and claims of negligence from Extreme. By signing this contract, retweeting it to its followers, and choosing to ride a mountain bike, the plaintiff also agreed to the mountain biking standards of care. Today, the standards of care expert, Professor Grom Atherton, informed us that a reasonable rider would ride in control, abide by warnings like yield signs, and examine the terrain before riding. Yet Mr. Kolshen chose not to yield to two hikers and caravans of horses he encountered on the trail, chose not to ride in control, and chose not to examine the terrain before riding. The plaintiff's astonishing disregard emphasizes the contrary negligence as defined by Jury Instruction 9. On the other hand, Extreme went out of their way to keep users safe. In addition to posting warning signs that Professor Atherton found superfluous, Mr. Dockabed consulted an expert mountain biker, Chase Bale, and visited neighboring trails to find that the Wonder Trail's washout feature was not a hazard, but rather an invitation for mountain bikers. With Mr. Kolshen being the only mountain biker to ever complain about the feature's visibility. As Professor Grom Atherton testified, mountain biking is inherently risky, but that trail features are not dangerous unless bikers behave negligently. This inherent risk is not to be confused with negligent maintenance. The plaintiff also alleges that Extreme negligently operated the snowmaking equipment. However, Mr. Estepe explained to us that the risk of blowback onto the Wonder Trail is minimal due to the warm May weather and the steep cliff and the trees protecting the trail. In fact, Ms. Booker was on the trail and only felt a brief spritz of moisture from the cannon. In terms of noise, we saw that Extreme's contract warned users about the possibility of resort operations, including snowmaking at any given time. Ms. Booker expanded that loud noises were common and expected in the mountains, which the plaintiff would know, having spent many years on Mount Coteau. Now, much of the plaintiff's argument rests on the thoroughly discredited analysis of Ellery Parser, who even admits to not being a safety expert nor a certified safety professional, and sloppily attempted to apply a formula designed for paved highways and to mountain biking stopping distances. Mr. Parser also based his inaccurate conclusions on the noise and precipitation from a cannon in which he never even observed. The plaintiff also relied on a biased testimony from Valhalla, who was revealed to harbor prejudice against Extreme and her boss, Ms. Dockabed. Your Honor and members of the jury, the burden of proof is like a tug-of-war. The rope must be pulled just across the midline to determine liability, and today the defense has reeled the rope entirely. Overwhelming evidence indicates that Extreme demonstrated extraordinary care and that on the other hand, Mr. Colshan made contributory negligent choices that accumulated in his injuries. The defense trusts that Your Honor and members of the jury will prevent Mr. Colshan from diverting the blame due to his fall from fame, and by returning the only verdict justified by the law, that Extreme was neither negligent nor responsible for the plaintiff's injuries. Thank you. The defense rests its case.
Thank you, counsel. So since the plaintiff has the burden of proof, it has the last turn in argument. Do you have any further argument, counsel?
Yes, Your Honor. Members of the jury, I agree with Ms. Jawanda. Someone is devoting the blame here. Extreme Sports is improperly devoting the blame because they wanted a rise to fame. They wanted to be extreme, and they wanted to have an attraction that would attract mountain bikers. They're devoting the blame on the victim when the blame should be on the negligent company. Now, the defense counsel tried to tell you that my client, Mr. Colshan, assumed the risk. Now, I'd like to begin with the terms and conditions. Today, you heard the defense's own expert testify that a reasonable person would skim over the terms and conditions. And that's what Mr. Colshan did. These terms and conditions, they didn't mention anything about a latent hazard in the middle of a trail. Next, they talk about extreme signage. Now, they said that extreme signage was adequate, that Nikki Colshan should have expected the hole in the trail based off of those signs. Members of the jury, that signage, it's warning about difficult and dangerous terrain. Now, we've established that the hole in the Wonder Trail, it was artificially created. It's an artificial hazard that isn't part of the terrain. It's not part of the land. Challenging terrain can be expected. A latent hazard cannot. The defense tried to spend a lot of time talking about precipitation. Members of the jury, we're not talking about precipitation or anything that blew off of the snow cannon. We're talking about the loud noise that startled Mr. Colshan. Extreme Sports is a well-named company. They had 4 months to repair a hole. They didn't. They had 4 months to warn about a hole. They didn't. And they turned on the loudest snow machine without checking for mountain bikers, just as Mr. Colshan went around a blind corner. Members of the jury, find Extreme Sports liable. Thank you.
Thank you, counsel. Thank you to all the counsel and the witnesses. The trial is concluded. I'm going to give the raters a few minutes to finish what is by far the most difficult part or difficult role, certainly more difficult than mine. So I'll just make some general comments. I think both teams did very well. They both had to develop.
Judge Schmidt,
Yes.
if I could ask you to refrain from giving feedback until the raters are able to submit their scores so as not to influence them, because I trust that the raters wrote down their scores, but they're online, they're a bit behind.
Okay. I was just following the directions that said to make some general comments, but
No, we would totally welcome your general comments, though. They would be very helpful to the students. It's just a matter of the raters not being all on the closing argument section in the ballot. If we could leave a minute or two to have them get up to speed, that would be great.